Much for joining us this morning. My name is Suzanne Monk, and I am the Federal Trade Commission's Chief Counsel for Intellectual Property. I am also the Deputy Director of its Office of Policy Planning, and together with my colleagues, we are very grateful that you have joined us today. I'd like to express special gratitude to our panelists who have traveled from all over the United States to join us, and I am looking forward to a very productive session. Tomorrow, we will be joined by United States Patent and Trademark Office Commissioner for Patents, Drew Hirschfeld, and the Acting Chief PTAB Judge, Scott Bullock. I want to highlight that point because I believe that the PTO and the FTC have worked together in every hearing that we have held to look at issues at the intersection of antitrust and intellectual property. I think that's very important because one of the themes that you'll hear, particularly from this morning's panel, is that innovation is complex. It requires a number of steps from idea to development to commercialization. Intellectual property policy also is complex. It does not happen through the work of only the FTC or only other agencies. We all come together to make sure that we are looking for policies that do the best job of promoting innovation and protecting U.S. consumers. Tomorrow afternoon, we will close with remarks from Commissioner Rebecca Kelly Slaughter. I think that is particularly interesting because Commissioner Slaughter played a role in the development of the America Invents Act. So why is the FTC examining innovation and intellectual property policy? Well, as we've said for a number of years, innovation benefits consumers through the development of new products, processes, and services that improve lives and address unmet needs. Innovation rights are vital to the U.S. economy. In 2016, the U.S. government reported that IP-intensive industries support at least 45 million U.S. jobs and contribute more than $6 trillion to, or slightly more than 38% of U.S. gross domestic product. For more than 20 years, the FTC has used its policy and enforcement tools to engage with issues at the intersection of antitrust and intellectual property. We have convened hearings such as this to look at the role of patent quality, to look at the role of antitrust in promoting innovation. We have looked at the IP marketplace and remedies issues, and we have looked at more specific issues such as patent assertion entities and other IP concerns. Through that work, we have issued reports, drafted amicus briefs, contributed to policy discussions among interagency groups. And I want to highlight that point because you might think, well, how is what I am doing here today, sitting here today, going to contribute to the overall policy dialogue? And I think that if you go back and you look at the FTC's reports, you can see a direct link from what panelists say on the dais to the FTC's summary of those panel positions, to recommendations, to supporting our colleagues in the Solicitor General's office when it comes to address those issues before the Supreme Court. So there's a real trend from what we're doing here today to overall policy. Now, we shouldn't sit on our laurels. When Chairman Simons convened these overall hearings, he noted that a fundamental characteristic of a strong institution is a willingness to engage with new ideas, and in our case, changes in markets and business to consumer relationships. This decade has brought several changes to intellectual property laws in the United States. So it is an opportune time to explore the role of intellectual property in promoting innovation. For example, the America Invents Act was signed into law in 2011. The AIA is the most significant legislative change to the patent system since the Patent Act of 1952. It moved the United States from a first-to-invent system to a first-to-file system. It established new procedures to challenge issued patents, and it authorized the USPTO director to set its own fees. Within the last 10 years, we've also seen several significant cases from the Supreme Court. These decisions have affected a wide range of issues, from patent eligibility to fee shifting, from claim construction to venue, and myriad other issues. On the copyright side, parties continue to examine the application of the Digital Millennium Copyright Act, licensing issues, and the fair use doctrine. Content models are shifting from downloading to streaming. With Chairman Simon's objective in mind, we have gathered expert panels of academics, economists, and industry members to explore key questions at the intersection of innovation and intellectual property. This morning, we will hear from a panel of expert academics who will talk about the role of government in promoting innovation and the various ways that patents are used in different industries. I think you'll hear that there's not a homogeneous approach. Our second panel this morning will turn to business considerations. I'm thrilled that we've been able to assemble a group of practitioners to talk about the role of innovation in business decisions, particularly in early stage investment and venture capital issues. Then this afternoon, we'll move to the FTC's first copyright panel. We've noticed over time a shift to copyright issues, and it's time for us to stop and ask, what's the relationship between competition issues and copyright issues? So we will be surveying an expert panel this afternoon. Tomorrow, as I mentioned, we'll begin with a keynote from Commissioner Hirschfeld. Then we will move into an exploration of emerging issues in patent quality and patent litigation. We will have a panel of trade associations who will talk to us about how these changes have affected their members. One reason why we decided to collect trade associations in that panel is that we wanted to make sure that we were reaching the broadest sector of markets. Finally, we will close with a panel of economists exploring the literature in this space and policy changes of which the FTC should be aware. Finally, we will close with keynote remarks from Commissioner Slaughter. As you listen today, please think about questions that you have. We will have people walking through the audience to take your questions. They can come up to us. We also are trying to be very open in collecting public comments in this space. A number of you have submitted public comments already. I have read each of them and thought of them as we began to develop today's program. The public comment period for this hearing will close on December 21st. Now, before I begin the substantive program, I'd like to cover a few administrative matters. If an emergency occurs, please follow the instructions over the building's PA system. If we need to evacuate the building, please leave in an orderly manner through the 7th Street exit. After leaving the building, please turn left and proceed down 7th Street across E Street to the FTC Emergency and Assembly area. Please remain there until instructed to return to the building. If you've received an FTC's visitor's badge, we reuse those. Please turn that into the staff when you leave the building. And if you notice any suspicious activity, please alert building security. For lunch, there's a cafeteria in the building at the other end of this floor. It will close at 3 p.m. Restrooms are located just around the hall. And please be advised that this event is photographed and webcast and recorded with huge thanks to our amazing tech team. By participating in this event, you are agreeing that your image and anything you say or submit may be posted indefinitely at ftc.gov or one of the FTC's social media sites. The webcast recording, as well as a transcript of these proceedings, will be available on the FTC's webpage shortly after this event. If you have any other questions, please feel free to reach out to me or any of my FTC colleagues. We are here to help and very, very grateful that you have joined us either in person or via webcast. So with that, I will take my seat and introduce the panel. I am so excited for today, so excited for the discussion, and I'm just thrilled that you're all here. Thank you very much. So now I'm moving over here. This morning, we are joined, as I mentioned, by several exceptional academics in the space of innovation. To my left is Professor Tom Cotter of the University of Minnesota Law School. Professor Cotter has recently completed a book that explores the role of intellectual property in different market sectors. Next, we have Professor Rai. Professor Rai is at the Duke University School of Law. If you look at her bio, she has tremendous experience both in government and in academia, and so I think is well positioned to think about the policy objectives of government and the tools that we can use to achieve those. Next, we have Professor Pian Xu from the Georgia Institute of Technology, Scheller College of Business. She will present information today on innovation, trade, and the role of China in this dialogue. Finally, we have Professor Bill Kovacic, former chairman of the Federal Trade Commission. I was talking to Bill this morning and remarking on how he has been a stalwart in the FTC hearings. And he has a particular ability, I think, to take a critical eye to the FTC, but also make recommendations that will help us best use our tools to promote innovation and to protect consumers. So with that, I'd like to turn it over to our panelists, who will each give a 10-minute presentation, and then we will have a question and answer period. Thank you.
Well, thank you very much, Suzanne, for inviting me to participate in this panel today. I'd like to spend my 10 minutes talking a little bit about the role of patents in promoting innovation and briefly summarizing the standard economic theory of patents as an incentive to invent, and then talk about some of the empirical evidence as summarized in my recent book. And then I'll close with a few observations about the need to balance the benefits and the costs of patent protection. So the standard theory is that the cost of developing a new invention in terms of time, money, resources, uncertainty, often is very high, whereas the cost of copying often is comparatively low. And when these conditions hold, then from a purely self-interested perspective, it would be more rational to copy than to invent. But if everybody follows that strategy and becomes a free rider, then nothing is invented. Now, of course, those conditions will not always hold. Sometimes the cost of copying is very high. Sometimes the cost of inventing is not very high, in which case first mover advantages, lead time, may provide a sufficient incentive to invent. Nevertheless, the conventional wisdom shared by most economists is that absent patents or some other corrective, there would be an undersupply of new inventions. And given the importance of innovation to economic growth and human well-being, this surely would be a bad outcome. So in theory, patents solve the free riding problem by conferring a right to exclude or demand payment for a period of time, thus providing an opportunity for inventors to recoup the sunk costs of invention. So that's the theory, and what does the empirical evidence consist of, and what does it show? So first of all, over the years, economists have conducted surveys of firms to get a sense of how important, if at all, the patent incentive is to their willingness to engage in research and development. And the surveys generally show two things. The first is that overall, in terms of the role they play in helping firms to recoup their R&D, patents typically rank lower in priority than do alternatives such as trade secrecy and lead time. Now, that doesn't mean that patents are unimportant or never important, though the surveys do indicate that patents tend to be more important in industries such as pharmaceuticals, biotech, medical instruments, and specialty chemicals than in others. Secondly, there have been several studies that have tried to estimate what it does cost in terms of R&D to bring a new drug to market, and the best-known studies in this regard are the ones that have been conducted over the years by Joseph DeMasi and his colleagues at Tufts University using data provided by the drug companies. Their most recent 2016 paper estimates the average R&D costs incurred by multinational drug companies of bringing 87 self-originated new chemical entities, NCEs, and 19 new biologic entities, NBEs, to market at $2.6 billion. Now, studies are sometimes critiqued for various reasons. Other researchers do not have access to the underlying data, for example. Another possible criticism is that the study focuses on self-originated NCEs and NBEs, which may not be representative of the cost of developing drugs generally. Also, many drugs approved by the FDA are not NCEs or NBEs, but rather are new indications for existing drugs. But nevertheless, most of the other studies that have tried to estimate the R&D costs of bringing a new drug to market using publicly available data have concluded that the average cost is at least several $100 million. So whatever the correct number is, it's a large number. And with large upfront R&D costs, comparatively low costs usually of making a generic copy, most economists would agree that if any industry needs patent protection, it's the drug industry. By contrast, for most other industries, the relevant R&D costs are probably considerably lower, but more empirical studies, both with regard to drugs and with regard to other industries, would be welcome. A second point I want to make is that there are some other possible social benefits of patents, so that even if patents do not materially impact the incentive to invent in certain fields, it is possible that they are still serving a useful public purpose. Most prominently, there is the disclosure benefit, because patents are public records. They help in disseminating new technical information, although, again, the empirical evidence is somewhat mixed regarding how important this benefit is in practice. Disclosure also means that it's easier to license a patent than a trade secret, and for this reason, among others, patents may assist in the commercialization of new inventions. There's also a growing body of evidence, again cited in my book, that patents play a positive role in helping startups to attract venture capital. And in this regard, patents may serve as signals of the underlying value of a new company, which by its very nature doesn't have a track record and is not yet publicly traded. Again, however, more research on the extent to which patents effectively serve these other purposes of disclosure, commercialization, signaling, either in general or for specific industries, would be welcome. And then I want to close with two caveats. The first is that, depending on the circumstances, patents may not always be the best or the only way of inducing new inventions. It's important to at least consider the alternatives, such as grants, prizes, tax benefits for R&D, advanced market commitments, FDA exclusivities of various types. In my view, there's a role for all of these alternatives, although I also don't think that any of them are going to supplant the patent system anytime soon. One problem is informational. Neither the government nor any other central planner knows precisely what needs to be invented or how much of a reward to offer for its completion. The patent system, by contrast, has the advantage of being decentralized. Inventors go off and invent, and then the market, the wisdom of crowds, if you will, decides what, if anything, their contributions are worth. That said, however, the patent system is not perfect either. It isn't designed, for example, to provide incentives for the basic research that has no immediate or obvious potential payoff, so we probably need grants and other tools for that. And the patent system may not do a very good job of inducing inventions for which market demand is low, but human need is very high. For example, drugs to treat diseases that are endemic to developing countries, for which AMCs or other tools may be better suited. Yet another possible policy alternative to patents are other bodies of IP law. Software, for example, can be protected by copyright, and while the scope of copyright protection is less than the scope of patent protection, maybe that's all that's really necessary to induce the necessary R&D in this field. Alternatively, trade secret protection might suffice to induce the creation of inventions that are difficult to reverse engineer, although from the public's standpoint, trade secrecy may not be optimal because we forego the disclosure that comes with having a patent. And so for this reason, I do worry a bit that Mayo versus Prometheus and other cases broadly construing the law of nature exclusion to patentability may either inhibit R&D into new diagnostic methods, personalized medicine, or may cause inventors to opt for trade secrecy. And again, I think more research into the impact or not of the patent incentive as it relates to diagnostic methods would be very useful. My second caveat is that we need to remember that while patents may confer many social benefits, inevitably there are social costs as well, administrative costs, sometimes monopoly costs, transaction costs, and to some degree these costs are inevitable if we're going to have a patent system. And as some of the other panelists may be discussing, there is a healthy debate whether a competitive or somewhat less competitive market structure is in general better for fostering innovation. But patent doctrine and other regulatory efforts should be structured to reduce or eliminate these costs whenever they are unnecessary to fulfilling the public purpose of patents. So as I've observed before, if patent rights are too weak, we risk not inducing enough new invention, disclosure, signaling, and so on. But at the same time, if patent rights are too strong in terms of duration, scope, granting too many low-quality or trivial patents, at some point the social costs threaten to outweigh the social benefits. So the ideal patent system would be structured so as to maximize the surplus of social benefits over social costs. Of course, nobody really knows how to do that. Efforts to quantify all of the relevant costs and benefits defies empirical analysis. Nevertheless, using the best tools we have available of theoretical and empirical economics, I believe that policymakers often can be reasonably confident in predicting whether a given change from the status quo is more likely to lead us towards or away from this hypothetical sweet spot that best serves its intended beneficiaries, namely all of us.
Thank you very much, Professor Cotter. Professor Rye.
Thank you so much, Suzanne, for inviting me to these hearings. Professor Cotter has done a very nice job of walking us through the role that patents and other types of intellectual property play in different industries and for different types of firms. And he's also touched on the reality that there are other tools that the government has at its disposal for promoting innovation. I'm going to dig a little bit deeper into some of these other tools and some of the data on innovation, particularly research spending that my colleagues and I at Duke have collected over the last few years. This data has interesting implications for innovation generally and also for thinking about patents and intellectual property as policy tools as well. So, as with patents and other types of intellectual property, the other policy tools that government has at its disposal do play different roles in different industries as well. So the project that my colleagues and I conducted ran from 2016 to 2018. It was funded by the Kauffman Foundation, and it assembled literature on changes in the U.S. innovation system as a whole and the extent to which, if any, these changes represented a policy concern. We concluded with a report from our former executive director, Stephen Merrill, that suggested that indeed there was a policy concern and enunciated some policy recommendations. So first, has there been a change in the innovation ecosystem? The tentative answer was yes, we concluded. We drew this answer basically from National Science Foundation data gathered through their annual Burtis survey, as well as some related analysis by my Duke colleagues Ashish Arora and Sharon Blenzen. these data indicate that the private sector has shifted over the last 30 or so years from spending on research towards spending on development. The shift has been happening basically since the 1990s. This trend could be seen as worrisome. Alternatively, it could be argued that perhaps research has simply become more efficient. We think on balance, there is some reason to be concerned that the private sector has shifted out of research to a significant extent, particularly outside the biotech and pharma industries. Biotech and pharma are exceptions in this arena as well as they are, it seems, in the use of patents. By contrast, industries like the computer, electrical, and semiconductor industries have seen much greater declines in their expenditure on research. So what are some potential causes? Here, we are reluctant to say too much, but one point is worth mentioning, I believe, and that is since this decline in research has been happening since the 1990s, during a period of time when patent law has shifted significantly from being extremely generous towards patents towards perhaps being less generous in the last, say, 10 years. At least as a first order matter, patents cannot be the major explanation for why there has been a decline in research outside of biotech and pharma. In addition, it's of course worth noting, as Professor Cotter has noted, that patents and other IP, particularly patents, tend to be a double-edged sword when it comes to innovation. They promote innovation, but they can, in certain cases, also create transaction costs for innovation. So we conclude on balance that patents are probably not the major player here, and we have reasons to be concerned about other factors. Some of these factors will be discussed, I believe, by Professor Xu as she speaks on the role of China and trade, but I did want to note another potential factor that has been highlighted by my colleague at Duke, Alon Brav, who has noted that although hedge fund activism can increase the efficiency of R&D investment, it probably does reduce R&D expenditure on balance by firms, and so that's a potential area of causation as well. Finally, I want to conclude with what the toolkit could be in terms of interventions. So in the paper authored by our former executive director, Stephen Merrill, we speak a lot about the role the federal funding can play. Professor Cotter has talked about that to some extent, but I want to highlight one particular piece of that white paper, which I think gives away what we think is a key problem with research funding. And the title of the paper is Writing the Research Imbalance. What is the research imbalance? Well, the research funding for the life sciences has been quite robust over the last 30 or 40 years. In fact, it now represents a significant majority of the federal science budget. By contrast, the physical sciences and engineering research budget has fallen from 41% of the federal science budget in 1980 to 28% today. Life sciences has picked up all the difference. So we think that that's a policy lever that can and should be used. Fortunately, it appears, at least in the last few months, Congress has heeded some of those warnings, not simply from us, but from many others, about trying to right this research imbalance, and that is good. But we hope that that will continue to be the case, even as this current budget cycle, we move on from this current budget cycle. I will conclude with a couple of notes about IP, which happens to be, of course, the area in which I study most intensively. I, too, share concerns already enunciated by Professor Cotter about the role of the patent eligibility decisions, subject matter eligibility decisions handed down by the Supreme Court, particularly in the area of medical diagnostics. And I've done some research, some empirical work in that area that I'm happy to talk about in the question and answer session as appropriate. The issue, of course, if one is to address the 101 question, is how to fix it. And it's a challenge to come up with good language. And I think everyone who has considered the question thoughtfully would recognize that the challenge of statutory language change is a significant one. So perhaps judicial evolution is the way to go, and we will see if judicial evolution brings us to a stage that is a better equilibrium. And then finally, I want to note one piece that brings together both sets of my comments, or one point that brings together both sets of my comments, and that's the relationship between intellectual property and public funding. As many of you probably know, the fruits of public funding can, for the most part, be patented now as a consequence of Bayh-Dole, and I think Bayh-Dole, on balance, has been a very good thing. However, it would be very good, and this goes beyond the typical academic plea for more data, it would be very good if we could have more access to information on exactly how universities and other recipients of federal funding commercialize innovation, because to the extent that our academic center industrial complex is a unique feature of the U.S. innovation ecosystem, and I think it is, it would be good to have more information that we could, and data that we could analyze on that question. So I really appreciate this opportunity to speak, and I look forward to the question and answer.
Thank you very much. And Professor Hsu, I know that you have slides. I don't know if you'd like to take them there or here. I have a...
Yeah, I can take from here. Yep. Thank you. And do I just press that?
Yes.
Okay, great. Okay. All right, thank you so much for having me here and for putting together this excellent panel. So I want to actually talk about some recent empirical findings looking at the impact of competition on innovation using actually patents as a measure of innovation. So this sort of kind of shifts the gear a little bit where you know, I'm not going to be talking about the IP policy per se, but actually looking at research using patents as a measure. So in this sense, like me and my innovation colleagues are sort of consumers of the IP system where we use patents as measures. So this is based on two work with co-authors. One is an empirical study and another is a literature review. So the key question here is that we're interested in understanding how import competition from China affects the innovation in the US. And this is particularly of interest because Chinese imports represents a major source of increase in competition in the US, especially in the manufacturing sectors. So as you can see on this graph, imports from China over the last several decades grew from really, you know, nothing to over to nearly 3% of the US GDP. The exports to China also grew as a part of the increased trade, but not nearly as much as imports. And there are several interesting sort of characteristics of this rise in import competition. One is that I think the timing of this increase in Chinese imports is sort of unexpected because China actually experienced a lot of political economic uncertainty in the late 80s and early 90s. So even in, I believe in 89 or 90, Wall Street Journal published, their outlook for the next century, and they actually ranked China as one of their least, expected country to grow. So that shows you that at the time when China started opening up and shifting towards a market economy, that wasn't necessarily an event that many people expected. So that unexpected timing actually represents a really good, opportunity for empirical economists to study sort of the impact of this rise, precisely because it was unexpected. And the second characteristic is that the sort of the increase in this competition is also unprecedented because prior to China shifting towards a more market-oriented economy, China was actually quite far from the production frontier due to, the more sort of the state-owned enterprises and how the economy was structured. So after they opened up, there's a huge shift towards that production frontier, which drove this really intense increase in the rise of imports. And finally, China has a clear comparative advantage in cheap labor, which also drives the, the nature of their production and their output. So So the rise of Chinese import competition to empirical economists like me is really interesting because it presents a really unique empirical opportunity to study the impact of competition on innovation, which actually is one of the longest debated questions in economics. So going back to Joseph Schumpeter in the 43, he's the first one to point out that competition actually can have a negative impact on innovation because it reduces the incentives of company to come up with innovation. So assume like a monopoly that have full access to the market. Obviously, the returns to innovation is quite high because they have access to the full market. In contrast, when you have a lot of competition, you have access not necessarily to the full market. That reduces the incentives to innovate. So that's what I mean by the Schumpeterian effect on the slide. On the other hand, the opposite argument is that competition can actually be a way to escape, innovation can actually be a way to escape competition and take market shares from the competitors. So if you don't have competition as a monopoly, you actually don't have any sort of like profits to replace. So the opposite argument is that competition can encourage innovation by through this channel of escape competition. So these two, one is a negative argument, one is a positive argument. These two are the major arguments on the impact of competition on innovation. And finally, there's a third channel, which is less examined empirically, but I think it's important to talk about theoretically, is that oftentimes there are managerial slacks in a firm where managers are not necessarily maximizing profit, but act according to their own interest. And competition can actually reduce this managerial slack by increasing the threat of, for instance, bankruptcy. So in this case, competition can also increase innovation. So ultimately, this is an empirical problem where we, in my study, we look at the impact of Chinese import competition. And I do want to point out that although Chinese imports can generate competition for firms in the same industry, it is not the only way that it can affect firm innovation, because for firms in downstream industries, Chinese imports can actually provide access to important intermediate inputs. So what I'm presenting is actually only one aspect of how Chinese imports can affect firm innovation. So what we did is that we collected US PTO patent data matched to the firm level data for public firms, and as well as industry level data on trade exposure. So our analysis really focuses on understanding how changes in Chinese import penetration between 1991 and 2007 affect changes in firm patenting and other outcomes. And turns out this is actually not an easy analysis, because we have to control for sort of think about how US firms demand and US technological trends, how that could affect patenting, right? So what we really wanted to do is isolate the exogenous variation in the Chinese import penetration and link that to changing firm outcomes. And we do that by looking at, I'll obviously skip the details here, but we look at this using, Chinese imports to other countries, as well as policy changes in the US to really identify this exogenous variation. So to summarize our key findings, we actually find, first of all, we find that Chinese import competition had a negative impact on firms' financial outcomes in terms of, for instance, sales, profitability, and employment. So this shows that Chinese import actually did increase the competitive pressure that the US firms faced. And as a result of this increased competitive pressure, we find that the import competition had a negative impact on patenting, which we use as a measure of the innovation output, as well as R&D expenditure, which is an input into innovation. So taken these together, the results suggest that competition led to a contraction of US firms in both production and innovation. So firms in industries that faced more competition contracted more or grew less than firms faced with less competition. So sort of the first, reaction to this finding might be that, a sense of concern that this potentially represents a slowdown, in the innovation and growth in the U.S. And I want to just shout out to Paul Romer, who just won the Nobel Prize, for pointing out that innovation is an engine of U.S. growth. So viewed in this light, this is a sort of a pessimistic reaction to these findings. However, I do want to point out that there is a more optimistic reaction to these findings, because Joseph Schumpeter, the person who came up with the argument that competition is bad for reduces incentives to innovate, is also the same person who talked about, who introduced the idea of creative destruction. So this idea of new entrants replacing old incumbents and new markets replacing old market is a natural part of how market grows and evolves. So these are the two sides, and I think one aspect to consider in this is how much of these reduction in patenting and R&D expenditure represents an overall decline in innovation capability versus how much of it is through reallocation from, for instance, manufacturing sector to service sector. So that is an open question. And finally, I just want to quickly put these results in context, because any empirical results, if you want to think about the interpretation, it's really important to think of some of these characteristics. So how competition affects innovation depends both on the nature of the competition as well as the nature of the home market. So in the case of the Chinese import competition, I think two characteristics are really important. One is that, as I mentioned, it is an unprecedented increase in intensity of competition that could be unrivaled if you just look at changes in domestic competition. And the second is that this competition also concentrated on the low-cost, lower end of the market. So, and the nature of the home market also matters, because other studies have found Chinese import competition to have actually positive impact on firm innovation in Europe and developing economies. And if there's interest in Q&A, I can explain more about how to reconcile these different findings. And finally, I do want to quickly mention that access to important intermediates, so the supply chain effect, is actually, there's overwhelming evidence, not using international market, not necessarily US firms, there's overwhelming evidence that this access to imported inputs, it has positive effects on firm innovation. So any policies that think about changing import competition per se, must take into consideration of its overall impacts on supply chain and competition and other aspects of firm activities. Thank you.
Great. Thank you very much, Professor Xu. Finally, Professor Kvasik.
Thank you, Suzanne and John and Bilal, for the wonderful opportunity to participate in the discussion today. It's good to be back home. I'd like to talk about the role of the Federal Trade Commission as a means for policy development involving innovation and intellectual property. If we go back a century, you see that the FTC took shape in a period of revolutionary developments in technology and in the application of intellectual property. In this period, in the area of transportation, it was the development of the automobile, oil-fueled steamships, and the airplane. In communications, the extraordinary rollout of the telephone as a means of communication, the development of the radio, and what was then called the wireless, not the current wireless, but what was known then as the wireless. And in the area of entertainment, the emergence of a new device called the moving picture, and soon to be the talking picture. To citizens at the time, these changes were no less revolutionary than the developments that we see today. And to the Congress, a key question is how, for purposes of competition law, how does one respond to this? How does one understand them? And in crucial respects, the FTC was a core of the policy response, a response that encompassed a variety of policymaking tools. One was law enforcement, but a special type of law enforcement that would take place through a mechanism of administrative adjudication with a deliberately elastic substantive mandate, Section 5 of the Federal Trade Commission Act and its prohibition on unfair methods of competition. The agency would be governed by a board, not by a single executive, a board that would draw upon diverse backgrounds and expertise to address these types of issues. The agency would not simply be an antitrust enforcement body. in the special sense that I've described. Far more important, the Commission embodied a concept that we describe today as competition policy, not simply antitrust enforcement. You would have a deliberately broad research and data collection function embodied in Section 6 of the Federal Trade Commission Act to collect information by use of compulsory process, to issue reports without contemplating necessarily the prosecution of cases. And it would have a special role to play as a convener, to hold events like this one, to hold a series of proceedings that would provide a basis for learning, discussion, debate, and the development of a synthesis with respect to specific issues. And in many respects, I think through its history, the agency has achieved the fullest expression of this vision in dealing with issues such as innovation and intellectual property. Before the past 20 years that Suzanne referred to, extraordinary work involving the pharmaceutical sectors, a report on tetracycline, litigation involving the use and misuse of the tetracycline patents, the exploration of patent thickets in cases such as the Xerox monopolization case, and in merger review, simply to single out defense and aerospace, in the course of looking at dozens of mergers, the Commission's decisions have dealt fundamentally with the way in which innovation takes place in these crucial areas. A further step forward, though, I think takes place in exactly the way that Suzanne described before. The proceedings that begin in 2001 and culminate in the production of the To Promote Innovation report in 2003 is a broader realization of the capacity of the agency to serve as a convener, to elicit views from a variety of different perspectives, and then to distill that learning into a report that can be a source of guidance for policymakers, for judges, for legislators. Those undertakings took over 20 days of hearings that took place in different venues across the country. They began not in Washington, but in California, the campus of the University of California at Berkeley, where Kenneth Arrow and other luminaries in the field came together to discuss the fundamental issue that Tom, Artie, and Pian were just referring to. That is, what role does competition on the one hand and the protection of exclusive rights on the other hand, what roles do they play in the development of an innovative and dynamic economy? The result of this was a formative report that dealt with the impact of the rights granting process on this system, a report that became a focal point for discussion and debate in the United States and has had a dramatic impact on the way in which foreign jurisdictions and international institutions conceive of these issues. It's become a focal point for judicial development of doctrine, notably the Supreme Court in several cases referring to its work. What stood out about this is that this was not litigation. This was a conscious strategic decision by the agency to devote high-quality resources to the development of this convening role and function and to publish reports in the expectation, somewhat of an act of faith, that if done well, they would have a major contribution to these other areas of policymaking. And they required a major investment. This was a significant use of time. Both the predecessor bodies of Suzanne's group and others brought together some of the best resources in the agency, far and away above university quality research faculty, to do this kind of work with an impact that stands up. There was the further strategy to follow up with this, to continue it, continuing reports and research on patent remedies and on non-practicing entities. All of it involving a continuing conversation and engagement with the disciplines of competition law and economics, intellectual property law and economics, and the affected business community. If we look at the foundations for this kind of work, and we think about what it takes looking ahead, it requires the agency to think about the best use of its capabilities, to formulate priorities in a conscious way, and the priority here was innovation in intellectual property, and to wisely select projects that can realize the application of these special skills. And it also required the continued investment in building the human capital and accumulating it to do the work well. This work can't be done on the cheap. It takes resources away from what might be the next case. It's not case-specific. It is deliberately devoted to preparing a good research product that can have a major impact and marshaling resources to that end. To look ahead, what do I think are the implications of this for the FTC's role in the future? As you might gather, I'm an enthusiastic supporter of this realization of the agency's role and its contribution to policymaking. First, investment. There's plainly, I think, based on past experience, a basis for seeing that this kind of work deserves continued substantial investment by the agency, even though in a narrow sense it does not generate the cases that tend to end up on the front page of the newspaper or the front page of the business section of the daily publication. Thus, it requires literally what would be the equivalent of research and development in the private sector. This is policy research and development. There's been a very healthy norm that supports its pursuit and development, and that becomes important once again here. Among the focal points could be an expanded effort to see how intervention by way of litigation in the past has affected innovation, the way in which merger remedies in other cases have affected outcomes with respect to innovation, with an eye toward the FTC becoming a uniquely significant repository for information and knowledge about competition policy remedies, and to be a global resource with respect to that crucial development of policymaking. A second frontier for policy development is what might be called policy integration. The agency was conceived first and foremost as a competition agency, but its role migrates, it expands over time to encompass, by statute in the 1930s, consumer protection. And that consumer protection function has spawned what arguably is a third distinct product line of policymaking, and that's data protection and privacy. A question to be asked in the future is, how can we draw upon this threefold combination of capabilities to pursue and development policy in this area? In short, how to use the special capacity inherent in our charter. And the last is policy implementation, indeed through the unique capabilities to act as a litigating body. To my eye, Section 5 of the FTC Act, administrative litigation, are the best home for policy development should litigation be seen as the right way to look at issues such as standard essential patents, FRAND obligations and their implications. That is, the FTC has a unique capability to operate without the specific constraints of doctrine that come from the interpretations by the courts in Sherman Act and Clayton Act litigation to do special things in this area, all premised on the research and development that come from its non-litigation roles. Thank you.
Well, thank you very much, and thank you everyone for your very thoughtful presentations today. My colleague John Dubiansky and I have prepared some questions, but I also wanted to open it up to each of you to ask questions of each other as we sort of go. So I'll kick it off. We've talked a lot about innovation as an engine for economic growth. And I think we've also heard from our panelists that innovation is not homogeneous. It depends on which sector you're in, it depends on which stage of investment you're in. So I'd like to ask each of you, as the FTC considers its role here, what are the key factors to consider when evaluating policies to promote innovation? How do we test if we're on the right path? And does that test change by industry? And so I'll open it up to everyone if you'd like to join in.
Let me say, as far as the patent system is concerned, one of its strengths as well as one of its weaknesses is that the rules tend to be uniform. In fact, we are largely locked into that rule as a result of international treaties, and that's probably a good thing. The TRIPS agreement forbids discrimination based on field of technology. But it also can be a weakness because, of course, some industries make larger investments of R&D compared to others. And so, in theory, the optimal system would be one that tailored patent rules to the needs of different industries. But as a practical matter, I think that would also induce a great deal of rent-seeking. Each industry would then lobby to be the favored one, and so maybe on balance it is better to have uniform rules. But that means that the rules might be stronger than necessary for some industries and perhaps not as strong as they should be for others. The courts, however, can and do, when applying patent doctrine, apply them in somewhat different ways for different industries. For example, in evaluating how much needs to be disclosed in the patent document, I think it is fair to say as a general matter that you need more disclosure in the unpredictable arts of chemistry and biotechnology. So there are some modifications that the courts can make at the margin. To the extent we want more tailoring, though, we may need to rely more on other policy levers, such as those that Artie Wright talked about, FDA exclusivities, and other tools.
So Tom, as we're thinking about each of those issues, whether you would want to have different grant terms for different arts, or whether we should be looking at the patent system together with other regulatory levers, what questions should the FTC be asking to think about how we can achieve our goal of protecting consumers in this space?
Well, I think it all does come down to the fact that any policy related to innovation will have its benefits and its costs, and it's going to be very difficult often to quantify and to compare those benefits and costs, but we need to see where the evidence goes. And so I think the FTC has done a very good job, for example, in its study a couple of years ago on patent assertion entities, in assembling the data and analyzing it. And that's what we really need, is the best empirical evidence we can find. There are people out there who are telling us now that patent trolls are a myth, or that the decision to go with a discretionary injunction standard was a bad idea. And maybe those people are right, but you can't ignore the evidence either. And there is some fairly good empirical evidence that patent assertion entities have caused some social harms. There's good evidence that patent holdup is a real phenomenon, not just some myth, as it is sometimes dismissed. But if the studies have been done improperly, if they have reached incorrect conclusions, then do better studies. I mean, but you can't ignore the studies. I think we really have to focus. Patent law innovation policy is more closely aligned with science than probably any body of law, and we shouldn't ignore the norms of science. We can't make up our own facts. We can't ignore the evidence. Anecdotes are not data. Test, falsify, and see what you come up with.
Perfect, thank you.
So I just wanted to add that, and this is very much along the lines of what Professor Cotter has said, that the possibility of experimenting, or at least evaluating in a very rigorous way new interventions, I think is one that the FTC does very well. And I'm proud to say that I think the Patent and Trademark Office, with the introduction of the Office of Chief Economist, has begun to do as well. So, for example, with the introduction through the American Invents Act of 2011 of the Patent Trial and Appeals Board, there's an opportunity to learn as more decisions from that institution body come down. And so, for example, I think that the recent, some might have see as a bad course correction, but at least an interesting course correction by the PTO towards moving away from the broadest reasonable interpretation standard for claim construction is based on some data, including data that I've generated on the role that these proceedings play in substituting for litigation and the efficiency benefits that might be realized by having the same standards in litigation in the district courts, in Article III district courts, and administrative agencies. So I think that's a course correction, as contrasted with perhaps some of the anecdata that Professor Cotter was talking about, that is based upon data.
Great, well, thank you. I'm hearing from both of you the role of empirical evidence in promoting intellectual property research. Is there a mechanism if you're sort of either beginning an empirical project where you're trying to understand the sort of foundations of the question that you're looking at, what else can you look at as you're beginning to develop that empirical approach? So I'm thinking, like, if we were to start to look at an issue completely from scratch and we wanted to have the empirical approach together with looking at theory, how would we balance that? What would you be thinking about in that space?
So the concern with empirical work, and I've seen this in my own work, is it takes a long time for the data to emerge. And so we had to wait until 2015 really to have enough data on how the PTAB was actually being used before we could say anything. And that does, so in theory, there was a lot of pressure on the PTAB to say that, well, you are operating because this is what Congress wanted you to do. You are operating this way or that way. But while all the loud voices were speaking, unfortunately, it took a while to actually figure out what was happening, and the loud voices always come first.
Yeah, and I guess that's the delta that I'm asking about, is the approach to be more conservative in that space, or is what do you recommend?
I'm sorry, I didn't get
I guess what I'm asking is, so let's take, for example, PTAB, right? The PTAB institutes in 2012, and the data starts to come in 2015. What's the right thing for policymakers to be doing with respect to the PTAB in that 2012 to 2015 space?
It's a great question, and from our standpoint, it was good that they maintained a constant policy, because then that didn't mess up our data. But that's obviously not, shouldn't be their concern necessarily. Yeah, so, but I think that is the negative side of any new intervention one tries. One doesn't know for a while whether it's actually working, but that's just the reality. And I think that to swing back and forth wildly without data is a bad idea, even if it can be frustrating sometimes to have to wait.
Thank you. Professor Hsu.
And I actually wanted to add another aspect of adding to the delta is the data collection. So in our study on in our study, we actually spent 3 years cleaning up the patent data and matching to firm data, because the patent data doesn't have, identifier for the firms, and the firm names are very, self-entered, are very noisy. So it turns out matching the patent data to the firm data was not a trivial effort. So my larger point is that I think when you think about effectiveness of studies, the measurement issue is very important. And on the measurement issue, there's both sort of cleaning up the patent data, which I think USPTO has done a great job. They have released the patents review, which is a great effort to, clean up the data. As well as, I think, the larger question of how to measure innovation. So are patents the best measures of innovation? I think it is, one of the best of measures we have, but clearly it doesn't measure all of the innovation efforts. So that actually relates to a question that I want to ask the fellow panelist, which is that, what do you think are the best measures of innovation, and can we do better than patents? And also R&D expenditures, of course.
Yeah, no, I think that's a great question, and it's a question that we thought about a lot when we in our recent work have looked more at R&D expenditures or R expenditures, and of course the pushback to that is that, that's just the input. What we really care about is the output, and so inputs are nice, but they're not really what you want. And then the problem with patents is output measures is well rehearsed. So. Yeah, I mean, I think that, if we could actually have more sophisticated measures, that would be very much a good thing. And I take it that the National Science Foundation has at various points tried to come up with better innovation metrics than either patents or inputs. But I don't know that any of that has really led anywhere.
And of course, the ultimate goal is economic growth. I mean, going back to Paul Romer and the endogenous growth models, that innovation is both an input and an output. So the ultimate goal is not to increase the number of patents, but it is to increase economic growth, and patents are one tool for doing that. But none of our ways of quantifying or measuring innovation are perfect.
Although we do know that total factor productivity seems to have, at least on some measures, declined, and that's probably not a good thing in terms of innovation, because innovation is what TFP is all about.
Professor Kovacic.
When you look at the experience that a competition agency accumulates, and the FTC is one of them, I think you see that they accumulate the equivalent of big antitrust data. This is a lot of information that comes from pursuing individual cases, especially doing extensive investigations and cases within a specific sector. It doesn't always give you an insight from an economy-wide perspective, but in looking at specific agencies, I think it helps provide some insights to the points for the points that we've been discussing, and maybe helps you start to creep up on answers to some of these larger questions. For example, in the area of aerospace and defense, you see confirmation of Artie's point about how the crucial role that government funding plays in the development of specific technologies. When the FTC looked at the United Launch Alliance joint venture proposal, a key question was, would NASA give SpaceX, which had not launched anything yet, it had launched ideas but no hardware, would NASA give SpaceX contracts to do non-national security launches of different kinds as a way of establishing its credibility to become an effective supplier to the whole range of government purchasers in the future? The assumption that it was a crucial part of the decision to allow the United Launch Alliance to be formed. And fortunately for U.S. citizens, for the aerospace sector, that assumption proved to be correct. But it was vital that the public purchasing agency play the role that it did in fostering the development of a new business model, which has been, in many ways, a dramatic departure from what existed before. You could imagine that in sectors in which the agency has been quite proficient, that you do the equivalent of industry studies. That is, you try to reflect on the dozens of mergers done in the pharmaceutical sector, which allow you to assess the role of perhaps of research and development, the significance of rivalry across different producers, the fascinating role that collateral regulators and public policy makers, such as those in the Food and Drug Administration, play in the development of the sector. You could go sector by sector where the agencies have deep expertise and use the big antitrust data that they've assembled to derive some observations about how innovation takes place, what role different forms of intellectual property protection play, and what role competition plays in stimulating the development of those sectors. You could go beyond that and develop the research agenda that, again, is uniquely within the province of the FTC. The FTC can get a lot of data. It can collect information that would assist in providing answers to a number of the questions that we posed. How might you go about doing that? Alan Fels, who was the chair for many years of Australia's Competition and Consumer Protection, but also a specialist in public administration, said that public agencies had to draw upon what he called co-producers outside of their own walls to carry out their own missions effectively. One that Alan identified is the world of academic researchers. And you could imagine a collaboration in which the academic researchers assist you in putting together what the research agenda should be. The FTC helpfully does have a microeconomic policy conference every year, which is a way to try and draw academics into the development of research projects that are supportive of public policy making. But you could imagine that one way to formulate the FTC research agenda would be in a more systematic and elaborate way to draw upon researchers and ask, if you could get the data, what would you like to have to assist in formulating what the specific research project would be? And then the FTC goes about carrying it out. With its budget, I wouldn't suggest that the FTC can do a Manhattan-like examination of the economy and all it contains and all of its origins and sources. But you could imagine taking the big antitrust data that the agencies have themselves to look at specific industry evolutions, plus the collaboration with researchers in a variety of settings on the outside to go about formulating the research agenda that would enable you to go forward and start to answer some of these questions, again, using capabilities that are uniquely within the FTC's own mandate.
No, I think that's an interesting point. Thank you. Because, as we were doing the PAE study, one thing that we need to do is to talk to our colleagues at OIRA to convince them that the benefit of the burden that we're placing on businesses outweighs the cost to the business. And so I think the idea of leading with academic research or in the case of the PAE study, we led with a workshop that told us that that data wasn't available. I think that's an interesting
And I
model.
think if you ask across the whole span of government institutions in the United States, which one has the greatest capability to do applied industrial organization research in a way that provides a mechanism for injecting it into the mainstream of policymaking, I would say the FTC has an unequaled capacity to do exactly that kind of work. And I realize it's not cheap. It takes time, and the results are not easily predictable. But what impresses me from the past experience is that the careful effort's been used before to formulate a topic, to identify the focal points, gives you a strong likelihood of coming up with the result that justifies the advice and guidance that you gave to OIRA in formulating those projects.
Well, thank you. I'd like to turn it over to John, my colleague in the Office of Policy Planning.
Thank you. I think that as the panel has so helpfully pointed out, when we think about both our own policymaking and empirical research tools and agenda, it's helpful to think that oftentimes questions of innovation do extend beyond simply the patent space. So I've got a question on really the role of government in promoting innovation a bit more broadly, and perhaps Professor Rai, you may want to field this first, and that is, looking at the past 20 years, what can we learn from earlier government efforts to promote innovation? And in particular, how can we use these lessons going forward?
Well, the first point I would make is a point I hesitate to make because I had not studied Congress intensively, but this is a point that relates to Congress. So one of the points we make, or my colleague Steve Merrill made in the Writing the Research Imbalance report, was that the Rising Above the Gathering Storm report, which was probably one of the National Academy's most famous reports regarding the challenge in physical sciences and engineering in particular, was issued in 2007. It called for a doubling of Defense Department spending for the physical sciences and engineering. And the America Competes Act followed swiftly, and it was just actually, for some of us who were looking at it, just a remarkable kind of piece of legislation to follow so swiftly from a policy recommendation by an esteemed body like the National Academies. Unfortunately, the appropriators didn't appropriate the money because the budget politics got in the way. There were caps on discretionary spending imposed in the 2011 Budget Control Act. So I think one of the challenges is we know, I think in some cases, what the right answer is, but it's really hard to get all the ducks in a row to get it implemented. Speaking of, Suzanne, you were talking about how to do things quickly. To get things implemented quickly, it would have been great had the doubling actually occurred in the 7 years that the America Competes legislation authorized. So NSF and NIST and the DRE Office of Science would have gotten that money, but it didn't. And not until 2018, just a few months ago, did we get some significant infusion of resources into those offices, which I think is, all of us would say is really critical, no matter what one's politics are for our future innovation economy. It's sad that it took more than 10 years.
Just building on that for a moment, what bodies within the government are best poised to advocate and ensure the completion of these sort of initiatives?
So I hesitate to bring up that particular example because I know the FTC that's not a space that really plays in funding for basic research necessarily, but it's a sort of an example. And so, yeah, I mean, I think that there are different agencies that could help to advocate. NIH has done a very good job of advocating for itself in the life sciences. I'm not sure why NIST and some other of these agencies have not done as good a job. I'm not sure that the FTC could play a role, but it is something that has struck me as a real having gone into the Obama administration right after the American Competes legislation passed and then seeing it just languish for so long, it struck me as a real problem. So I don't know that the FTC per se can do anything, but certainly it seems to me that, DOD could perhaps have done more. I don't know if it could have or not. And that's why I sort of hesitate to jump with full feet into how one influences Congress. But that's a point that I thought was worth highlighting.
Perhaps we'll go down in the opposite direction this time. So, Professor Kovacic, do you have anything to add on experience in the past 20 years of the role of the government in promoting innovation?
No, I think there are interesting observations that you can derive from some of the experiences of both the FTC and the Department of Justice and some of their peer institutions abroad. I think the hesitation in talking about it is that they are not broadly systematic. They are idiosyncrasies in each area that perhaps make one very cautious about drawing conclusions. But there are still interesting, I think, observations that can come from looking at the industry histories, which at least in an informal way start to emerge from the examination of what specific industries have done over time. Arguably, the Federal Trade Commission has been focused very intently on the pharmaceutical sector since the late 1940s. That's a long period of observation. Countless mergers, non-merger matters, remarkable case records developed, hearings and other proceedings that contribute to this. I guess a matter of methodology, a challenge, something that might be done is how do you integrate everything that you've learned from these kinds of experiences into formulating a broader view about what matters. I think if we looked at, for example, defense and aerospace, and you look at the fascinating transactions that the FTC has examined, you see this intersection of public and private initiative that I think allows you to identify, for example, the government's formative role as a buyer, not simply as the provider of what might be called R&D subsidies, but its role as a purchasing authority and how significant that can be. The role of the government in doing its own organic research and development, going back to the days of the Advanced Research Projects Agency and Vinton Cerf, who was a young contributor to that team at the time. And that is the origin of the internet. In many fundamental ways, those were government-sponsored efforts. So I don't know if the Commission, for example, or the Department of Justice could provide a systematic set of recommendations about what matters. But I think that there are exceedingly interesting observations that can come from having watched and touched these agencies in so many different ways. Defense and aerospace, I think, is a fascinating example of how that works. But also pharmaceuticals, another area where the Commission's been deeply involved. And a step one could take would be, how do we take, again, this vast body of antitrust big data and experience that one's collected over time and maybe look at these specific topics more intently and systematically, not all industries, but to pick a few, and to try to come up with some better answers. Answers that I think bear out, Tom's comment about how you get different results or you have different significance based upon what industry you're in. I think you'd verify a number of the observations that these and other scholars have made about how the IP system, for example, affects innovation. But I think there's a lot of fascinating information that would come from a deeper examination of experience with the body of big antitrust data that the agencies have, and that they can collect without tripping the GDPR.
Thank you. Professor Xu?
So since Bill mentioned defense and aerospace, one interesting example that came to me was that, the event of moon landing actually inspired a lot of young kids to study STEM and become, potential innovators. And that suggests to me that sometimes, government interventions can have not just necessarily unintended consequences, but consequences can be felt in a longer term. And I think this think about the supply side, so not just the demand for innovation, but the supply of innovative talent is important. And in some of my other research looking at the MIT alumni and how they choose careers and how they become innovators, one interesting sort of finding that emerged is that people's interest in becoming innovators, especially in science engineering, those kind of interests form very, very early. So, the role of government in there, I think it's interesting to think about. And maybe sometimes it's not explicitly targeted at those groups, but, some of these policies, such as the moon landing events, inspiring a new generation, I think those are interesting sort of, not side effects, I would call them, but interesting effects to think about.
Thank you. I think it is very interesting to raise education as part of this discussion as well. Professor Cotter?
Yeah, I think I would just echo what the other panelists have said. From my own standpoint, it's very easy to be focused on patents and copyrights and how important the patent and the copyright system are, and they are important. Certainly changes in patent or copyright doctrine can move the needle and either induce a little more innovation or a little bit less, and those are important things, but I think it is probably equally and perhaps more important to think about the role of both government and private entities in sponsoring basic research, for which then the patent system is designed to come up with applications. It's great to have a culture of entrepreneurship and education, freedom to think, to collaborate, have a conversation where nobody is excluded. I think all of that is probably more fundamental to creating a culture of innovation than anything else.
Terrific. Well, we have an audience question, actually a couple of audience questions for Professor Hsu, and people are asking, please explain the different results with respect to the EU and developing countries versus the US in terms of the positive impact of increasing competition from China. And that ties into another question that we were going to ask about sort of as economies become more global, how do you balance the domestic nature of intellectual property and other laws with global competition? So I think first I'd like to, if we can, go back to it's your slide 13, and I think we can do that by just going backwards.
Okay.
Yeah, and so I'd love to have you address that point.
Yep. Thank you for the question. So essentially, the measurements are very similar. So how we measure Chinese import competition and the source of variations are similar in these studies. So I would say there are potentially 3 explanations for the different findings on the positive versus negative impact. One is that the intensity of increase in competition is a little bit different. Arguably, U.S. experienced the most increase of the influx of Chinese import competition, and the intensity might be a little bit less in Europe and the developing economies. And the second, and perhaps most importantly, the nature of competition, in the home market is different. So in the U.S., and this is more of a speculation, and I think it's worth actually examining more with data, arguably the U.S. market started out, and there's some evidence for this, the U.S. market started out more competitive than the European and the developing economies market. So if you're already in a very competitive market and you have a huge influx of increasing competition, that tend to generate more incentives to contract and even exit the market than to innovate as a way to escape competition. On the other hand, if you're in a market that's starting out not very competitive and you have a little bit of increasing competition, that actually would generate increased incentives to innovate as a way to escape competition as opposed to, exiting the market. And finally, I think, again, this is speculation, is that there are perhaps some differences in managerial slacks across different economies, perhaps most slacks in developing economies. They're potentially furthest away from the production frontier, so there's a lot of efficiency gains from this increasing competition, whereas the U.S., especially public firms, are probably already very efficient and have not much managerial slack, so the efficiency gain from competition is not as much.
Well, thank you very much. And just sort of staying where we have about 10 more minutes for discussion, then I want to make sure that I save 2 minutes for your statements. So if anyone has anything they'd like to add on this global question, I'd like to take that. Otherwise, I've got a few other audience questions that I'd like to address.
I would say, and there is, to my understanding, a fair amount of evidence that patents affect different countries in different ways as well. And so whether it's a good idea for, say, developing countries to have patent systems very similar to those we have in the Western nations, as is required under the TRIPS agreement, I think there's a fairly substantial body of evidence that at least once a nation reaches a certain stage of development, that having a good patent system in place can be very useful in attracting foreign investment, foreign technology transfer, in developing domestic innovation, perhaps to some degree. But that may not be true across the board. And so once again, we have a one-size-fits-all patent system, and that's not always optimal on an industry-by-industry basis or on a country-by-country basis. At the end of the day, maybe it's the best we can do, but there are definitely some drawbacks.
Well, thank you.
One thing I do want to add on the global aspect is that, one question that our study raises is that, do U.S. firms shifting their R&D and innovation to other parts of the world, right? Especially the multinationals. On the U.S. patent data, we don't see that. So we haven't seen evidence of, huge increase of patents from China, although there is an increase, but not overwhelmingly. But I think that is a sort of an interesting follow-up question to think about, is the locus of innovation shifting around the world globally?
Terrific, excellent. Well, and as you can see, John and I are looking at a number of questions that have come in from the audience and trying to figure out how to balance that with time. But I want to sort of make a pitch for the public comment period. So if anyone is listening to things as we're discussing issues and you'd like to hear more or have more raise points for the FTC, please be sure to file a public comment. I think with the last really 5 or 6 minutes before we turn to your statements, I'd like to go back to Chairman Simon's ask that we continue to explore the role of the FTC and how we're doing our job. And I know, Bill, that he quoted you in that statement, and that's also been a position of yours.
Can't do that enough, I think.
So I think really my question to you is, for the past 20 years, more than 20 years, pardon me, the FTC's IP policy and enforcement efforts have focused on the role that competition and intellectual property law play in promoting innovation. And our tools include, as we've mentioned, 6B studies, hearings such as this, participating in amicus briefs. I think we need to ask, have we gotten this balance right, and what should the FTC be thinking of as we move into the next 20 years?
I think the habit of reflecting on a regular basis on the views of astute observers like my colleagues here about how policy is developing and having a conscious process of collecting views on that is the best process-related antidote that you have to a bad path dependency with respect to any set of ideas. So I think the culture and custom of the process of public consultations has provided, will continue to provide for an open-minded institution the best way to continue to make adjustments and refine. I think as we all sense in this area, there's an inherent amount of experimentation that takes place in setting policy the right way. In reflecting on my colleagues' comments here, I think that some measure of experimentation is inevitable. Experimentation involves success and failure. I'm not aware of success experiments that invariably point towards success. They involve policy failures as well. And there's no shame in the failure. The shame is in committing the same failure again and again when you ought to have some idea of making a change. So I think the virtuous cycle, which I see established in the agency's work, is one of acknowledging the experimentation with respect to its own policies and those of others, periodically and regularly assessing the consequences of that, and I echo all of my colleagues' endorsement of a habit of spending resources on after-the-fact assessment. And third, making refinements based upon what the assessment tells you. My sense is that that has become the culture and the habit of the agency. That's a norm, as academics call it. That's not a regulation that tells you you must do things that way. I think that is the best possible insurance that you will have a process of adjustment and reflection that points towards needed improvements over time.
Thank you. I think we have a couple of minutes if anyone else on the panel would like to address that. Otherwise, we can move to closing statements. Terrific. Well, I realize that I'm asking you to criticize me while I'm sitting right here, so I can appreciate that that might not be something that people would want to engage in. But I also, I keep plugging the public comments because I think that people have raised a number of issues that might not fall in the spectrum of criticism, but certainly fall in the spectrum of here's how you've been looking at things, here's how the economy has changed, and here's how you might want to look at things going forward. So I want to encourage everyone to think about that as they file public comments in this space. So now, as promised, I'd like to ask each of the panelists to spend a couple minutes talking about sort of either your closing statements or what you think the FTC should be focusing on as we move forward in this space, because we've been talking a lot about a number of different issues. As I mentioned at the beginning, innovation is not heterogeneous, and so it's not homogeneous, it is heterogeneous, pardon me. And so I'd be really interested in your thoughts.
All right. So I have just 3 brief points to make. One is that invention and innovation are very, very important to improving human standard of living, and to the extent that the patent system and other aspects of innovation policy can improve that, that's what we need to be focused on. It's important to honor and recognize the contributions of inventors, but the overarching goal is to promote the progress of the useful arts, as stated in the Constitution. Patents are one means to that end. Secondly, patents are not a guarantee that a firm will recoup its research and development costs, but rather patents provide an opportunity to do that, but ultimately the market will decide whether an invention contributes enough that it was worth undertaking. And then third, and I think this follows up a lot from what Bill just said and from what the other panelists have said as well, it's important to experiment, not to be too sure of ourselves. Again, patents, innovation policy more generally, is the most closely related area to science. And the hallmark of science is that we can't just assume that we know how the world works. And so we formulate hypotheses, we test them, and if the evidence refutes them, then we change them and we move on. And that's the way good science is done, and that's the way good policy should be done as well, particularly in this area.
So I have 3 points as well, although I had 4, and you took one of my points, which is experimentation. We've all talked about that. And I do think that it's important in a time when people tend to have strong points of view on almost anything to realize that strong points of view should always be subject to what my colleagues in economics call Bayesian updating. You update based upon what you see the evidence is. So the 3 points I have are as follows. In accord with what I said regarding the role of public funding, in particular in physical sciences engineering, and the relationship that public funding and or public procurement has with the patent system, I think we do need more research there. And I say that not simply because I would like more data on which to do research, but I think that unfortunately the data that's available on how for example, academic funding has translated into commercial products, which is another metric one could use, commercial products, is hard to find because the information, such as it is in a database called iEdison, which is not accessible to researchers outside the government, or even, as far as I can tell, to some researchers in the government. So it seems to me that if we can gather more data on how public sector funding has eventually led to the creation of products beyond the great anecdotes, which I think are fantastic about the internet. We know that there's a lot going on there. It would just be great on a more micro scale to know exactly how that has worked, and that requires open data, which is something that unfortunately that academic institutions have not been eager to get behind. They don't want their licensing strategies and so forth scrutinized very much. So that's one point. The second point relates to trade secrecy. I think that the evidence suggests, and I don't have a definitive answer on this, but the evidence suggests that trade secrecy is becoming more important, and it's really hard to study for obvious reasons, but if there's a way that government agencies, including the FTC, could study the role of trade secrecy, including in a global environment, more assiduously, to the extent that we're concerned that trade secrecy has become, or concerned or just recognize that trade secrecy has become more important to certain players who think that patents can't be enforced in some jurisdictions, we really need to study how that's working, and if that's a problem for purposes of the cumulative innovation in particular, because the trade secrecy obviously cannot encourage cumulative innovation in the same way that patents can. That's the second point. The third point just follows up on something that Professor Kovacic was saying regarding all the data that you guys have on particular industries, and I'm just going to make a pitch for perhaps investigating more closely whatever data you have on the pharmaceutical industries, including biopharmaceutical industry, because it does strike me that there we have something of a metric of output that is useful, new drugs, new molecules, as opposed to small variations on existing molecules, and or new biologics. And it's interesting to me that there's been a huge shift in the pharmaceutical sector away from so-called small molecule drugs to these big biologics, and those things are really expensive and are going to blow up our healthcare budget, as far as I can tell. So that may be something to watch.
Thank you. I want to also echo the my fellow panelists on the importance of experimentation, measurement, and effectiveness. I only have one point to add, which is that I think there's a lot more to do, especially in the academic research, in understanding the role of U.S. firms in that plays in global competition and global innovation. So what we have studied, the impact of import competition on the innovation outcomes of U.S. firms, is only one aspect of the trade liberalization. So there's surprisingly, in my literature review with my co-author Claudia Steinwender, we actually saw very few studies that look at the impact of export opportunities on U.S. firms' innovation outcomes. So U.S. firms actually have enjoyed quite a bit of increase in access to foreign markets, including China, and how that affects innovation. I think based on evidence using data from other countries, it's pretty overwhelmingly positive evidence on innovation outcomes. But we have yet to see a study or more studies using recent U.S. data. And secondly, also U.S. firms also introduced competition to foreign markets, right? So how that increased competition affects the innovation and productivity of foreign firms, that is also an open question. And I think all of these are interesting because it also is related to thinking more critically about the nature of competition. For instance, whether competition enters from the high end of the market versus a low end of the market, those probably also have different impacts on innovation as well, and that's another open area for research. So there are many great opportunities and open research questions, and I'm really glad to hear the FTC's interest in research and experiments and rigorous studies.
I'd like to make a pitch for three types of investment. First, the continued investment in building knowledge, of which this set of proceedings is one part, but the continued investment that would be the equivalent of a high technology company investing in its capability and its people to do work over time. I realize there's a tension for a public policymaker. This kind of work does not generate immediate observable results. It does not produce ribbon-cutting ceremonies where you can say, I sued this company, I collected this fine, I did this, that, and the other thing. It's an act of faith in many respects. But I think in our community, and certainly within the agency, a question to be asked every year, it almost should be broken out in the budget. What's the R&D budget? That is, how much are you investing in R&D to become smarter and wiser about the way the world works and share the results of that? So I think that's investment number one. Number two, investment in building the synapses that exist already but can be expanded with researchers outside the walls of the institution. You take a public institution that has a unique capability to perform this convening and research and analysis role. None other like it. You have a higher education system that has no peer in the world. Education in the U.S. has a few uneven spots here and there. At the higher ed level, would you swap it out for anyone else's? I don't think so. And to draw upon that uniquely remarkable resource to help formulate and carry out the research agenda is a useful investment. Last, the investment in building the relationships with other public institutions. So Suzanne, you mentioned how the PTO has been involved in all matters related to innovation, IP, convening events, and things of that kind. The FDA relationship as well, very important. I'd add one to the list, the U.S. Department of Justice Antitrust Division. When we look overseas, it would be nice if there were policies that seem perhaps coherent. And I realize maybe there's a real benefit that they are not completely coherent and that there is some contest for the views. I would like to have the sense that when that contest occurs, that texts, drafts are exchanged in advance before the contest takes place in the public arena of ideas. That should be an ongoing, deep collaboration between the two agencies.
Well, terrific. Thank you very much. And please join me in thanking the panelists and my co-moderator, John Dubiansky, for the panel this morning. We will reconvene at 11 o'clock. Thank you. welcome back to our second panel, which will be exploring understanding innovation and IP in business decisions. My colleague Elizabeth Gillen and I will be your co-moderators this morning, and we have assembled a fantastic panel. I'm a little biased, but I think they're a fantastic panel of folks who have various levels of experience and various sort of personal experiences looking at the role of early stage invention, looking at the role of investment, and looking at the role of intellectual property. So the panel that we just completed was a very academic view. Now we're pivoting to a little bit more of a business view, and I'm thrilled to introduce Nicole Morris, who is with Emory. She also has a deep background in sort of the practical aspects of intellectual property, working at several companies. We have McCall Rosen, who is from EXPA, who also has experience with Kickstarter. Greg Raleigh will be talking about his experience as an inventor and his experience with New Enterprise Associates. And we will also have Talal Shamoun, who has just a breadth of experience in a number of different areas, and he's with us today from Intertrust. So as I mentioned, each of you have experience with the business considerations necessary to bring innovative products to market. So I'd like to begin by asking each of you to spend approximately 10 minutes addressing the relationship between innovation, intellectual property, and competition as you've seen it in practice. And Nicole, I'd like to begin with you, please.
Sure. Thank you. I just want to say thank you for this invitation to be part of this really important discussion, and also just honored to be up here with these really dynamic speakers. The previous panel did an excellent job sort of laying out the foundation of some of the innovation policy concerns. So my remarks will really focus on my work with entrepreneurs and early stage technology, particularly early stage technology originating from universities and research institutions. And as Suzanne mentioned, I'll also draw upon my experience from working at multinational organizations as a researcher and then later on as managing patent counsel. So universities and research institutions play an important role in promoting innovation. Academic technology transfer is what's driving that economic development. The data that I will cite comes from the Association of University Technology Managers, and their report that I'm looking at this morning is from 2016. We're waiting on the 2017 data. It takes a little while for them to aggregate it, but it's about 195 different universities, research institutions, and also university hospitals, which tend to be a real source of innovation for the pharmaceutical industry. So in 2016, the Autumn report or Autumn survey stated that there were over 1,000 startup companies formed out of the university technology. In addition, the data shows that the U.S. research institutions continue to develop and invest in intellectual property that arises from the academic research. The federally funded invention disclosures grew about 6% in 2016. So that's pretty important. And if you think about federally funded research, we're talking about NSF, NIH, and those types of grants that are critical to most of the academic research labs anywhere in the U.S. So these discoveries born out of the university research can lead to more impactful applied research and new commercial products. The invention disclosure activity really is what drives or what we would track as a measure of the key indicator of levels of innovation, and this continues to rise. Disclosure activity over the past 5 years has jumped about 4%. And then these disclosures are what will eventually lead to patent filings. Provisional patent filings are up about 5%, and this is data from 2015 then to 2016. And then the overall patent filing activity continues to increase. I will just drop a footnote here. One of the things that the Autumn report highlighted, and I noted this when I was in practice, we're seeing a ton of activity for patent filings in the U.S. originating from foreign actors or foreign entities. So that also is kind of a big driver of the innovation. And the panel that presented before us commented particularly on some of the global challenges that we're seeing. And I think at some point during our discussion today, that's a key driver for competitive activity that is hard to really quantify, but is definitely relevant, and you see it play out anecdotally. So my last comment would just be to close and say that from the university standpoint, there's lots of activity going on, and we're seeing not only in the graduate federally funded research area, but the undergraduate sort of innovation activity is starting to really creep up and play a role in either startups or just new companies forming out of academics. So that is where I will close and let my other panelists talk.
Wonderful, thank you. Well, McCall, I'd like to turn to you.
Sure. So thank you, Suzanne and Elizabeth, excuse me, and everyone at the FTC, as well as my fellow panelists. I'm very excited for the conversation today. So I'm speaking to you today as a representative of a company that is working to bring ideas to life. So at EXPA, we are bringing together entrepreneurs and creating the environment that allows them to bring their companies to life at the earliest stages. We have partners who work on ideas at those earliest stages of ideation. We help to fund them and through their R&D phase and build them out into independent entities. We also work with outside founders who have a marketable idea and are looking for their first funding, as well as for a community that's going to help them through this unknown territory of starting a company. And finally, we also find projects that are just getting off the ground, looking for capital to take themselves to the next stage. Before I joined EXPA, about a year ago, I was general counsel at Kickstarter, the crowdfunding company. And there, what we were doing was providing a platform for creators who actually, kind of similarly to EXPA, were looking to bring their ideas to life. They appealed to Kickstarter's community of backers to accomplish that goal, to find people who were willing to back this idea that they put out there and they'd like to bring to life. So based on my experience both at EXPA and at Kickstarter, I have absolutely seen the power of intellectual property. I see that it is a valuable asset for a company and how through strong trademarks and patents, a company can develop a brand as well as an IP portfolio that puts it in a good position to face competition as well as to attract capital. More often, though, I will say that the role that I've seen the IP system play with early stage companies is as a weapon used to stifle innovation at its earliest stages. So both small projects just getting off the ground with crowdfunding or companies that are at the earliest stages of development at EXPA have been targeted by patent trolls. These are holders of low-quality patents who are using extortion, essentially, as a means of extracting value from their intellectual property. Now, I know that my experience is not unique. That's why in a survey of 200 venture capitalists just about a year ago, 100% indicated that the presence of just a patent demand letter, not even litigation, just a demand letter, is a major deterrent in deciding whether or not to invest in a company. And it's why 150 early-stage venture capitalists recently signed on to a letter urging Congress to address the patent troll problem. So a properly functioning patent system requires this delicate balancing between innovation and competition. But my perspective, and I hope to expand on this in our remarks today, is that the balancing has gotten dangerously out of whack as low-quality patents have proliferated in our system. So as we begin today's conversation and engage in, I think, what will be a spirited debate on these issues, I want to be clear about what it is that we're discussing here. We're talking about a patent system in which an average of 40,000 software patents are granted each year. And those patents are often laid out in unreasonably vague terms. Take that together with the fact that there's no easily searchable index of patents, nor is there a real consistency in definition used across patents. And you can see why startups and small businesses often face no chance when they're confronted with a lawsuit. We're also talking about a handful of reforms that have been passed in the last few years that have laid the groundwork for a better functioning system. The America Invents Act, which passed after nearly a decade of negotiation in Congress, hearings, bicameral negotiations. This set up a system that allows for a more fair and efficient method for startups and small businesses to defend themselves against spurious claims of patent infringement. So the AIA established something that's called the Inter Partes Review, or IPR. And this is essentially a system that is explicitly designed to ensure that the weakest patents are targeted. First, as of the end of 2016, only 0.002% of active patents were subjected to IPR proceedings. Of those, 55% were electronic or computer patents, 29% were mechanical or business method. Those are the patents where we generally find the weakest patents, very low quality patents. Only 7% of patents challenged in IPR proceedings were in the bio and pharma fields. So the IPR system doesn't just benefit startups and small businesses who are challenging the patent's validity. It also directly benefits patent holders who are advantaged by a well-functioning system that produces high-quality patents. And in fact, innovation has flourished since the AIA was passed. In the past 5 years, the US has risen from 10th to 4th in the Global Innovation Index. And R&D spending in the US has risen significantly, seeing a 44% increase between 2012 and 2017. Finally, we're also talking, when we talk about reform, about a couple of recent Supreme Court decisions, in particular, their decision in a 2014 case called Alice v. CLS Bank, in which the court ruled in favor of decreasing ambiguity and vagueness in software patents. So in that case, the court held that otherwise unpatentable abstract ideas don't suddenly become patentable simply through the application of a general computer system. The Alice case and its progeny have really helped small businesses in fighting patent trolls at the earliest stages of litigation. And I speak from personal experience, where at Kickstarter we were able to invalidate a patent that had been asserted against us using precisely the Alice decision. Now, this really decreases the cost of and the costly endeavor of staying in business, but it certainly doesn't eliminate it. You are still going through litigation and still going through motion to dismiss and are likely spending several $100,000s in that process, but it's a good step forward. So finally, I would just like to say that it's a truism to say that to talk about the incredible pace of innovation. But it's a truism because it's true. And innovation these days simply does not look like what innovation was like in the 18th century or 19th century. And our outdated patent system has permitted bad actors to stifle development of new ideas and to drown out legitimate inventors. The handful of reforms that have come through Congress and through the courts in the last few years have been absolutely necessary first steps to address the problems that face startups and small businesses. And we should build upon these reforms and look for ways to further modernize the system and allow it to keep pace with the direction that innovation has been moving for decades. Thank you.
Thank you, McCall. And Greg, I know that you have slides. If you'd like to take it from there, I can hand this down to you. And also, if you're not using your cell phone, if you could move it away from your microphone, I think that that's giving us some interference. Thank you.
Well, great. Thank you, Suzanne, for inviting me. I'm here to provide the perspective of someone who's been an inventor for well over 30 years. I've also been an entrepreneur at 3 startups that made some of the world's most important wireless technology that we all use today, in roughly 3 or 4 billion devices. And now I'm a venture advisor at NEA, one of the world's largest venture capital firms. We invest in everything from life science to tech, from seed to pre-IPO. We specialize primarily in Series A and Series B. And one of my main roles there is to evaluate deep technology, and most of which requires some form of patent protection to invest in. I think this is a fabulous 1-2 punch here because I believe Mikal believes everything she just said. This is the argument that all of these are patterned directly after the arguments used when AIA was motivated. And from the perspective of someone who invests in, say, open source software and things that don't require patent protections, it's a valid viewpoint. But from my perspective, what we've done with the AIA, the changes in the court, some of which Mikhail quoted, we have pretty much destroyed incentives for foundational invention. And what I'm going to do is just tell you from the trenches how this works, what it means for an entrepreneur or an inventor trying to invent a big invention today. And I'll show you some data that is very, very difficult to refute, showing what's actually happened to big inventions. And again, I want to emphasize there are many types of innovation. Innovation is a new software product, maybe a change to an enterprise product or a consumer website, a social network, an app. Those don't really require inventions. They require innovation that relies on other people's inventions. Inventions change the world, and inventions require hundreds of millions, if not billions, to invest in many cases, and we've destroyed those incentives. So we all know that the patent system is not perfect, and that was cited earlier, but it's worked pretty well. And I think it's very hard to argue that one of the reasons the U.S. enjoys the leadership we have in technology, life science, and across the board in many industries, materials, drugs, is because we had the right for an individual or a small company to own an invention, prevent others from developing that invention and selling that invention. That's called a property right. You don't really own a piece of property when someone can squat on your property without paying you, and the only recourse you have is to try to get some rent, and if you can't get rent, you're out of luck. That's the world we live in today. This patent troll narrative, which we were very cheered last week when the current USPTO director started debunking the myth. There is something called a patent troll. That's an entity that preys upon small companies and uses crummy patents for extortion value because they charge less than the litigation value for that. That type of entity has existed. It's very difficult for those entities to exist today because it is true the changes we've made have harmed those entities and made it very difficult for them to practice. But in the process, we've also washed out invention and the incentives for invention. There are other ways to address the troll, which hopefully we'll get into today, and those involve federal trade practices and policies and laws to go after bad behavior, not inventors and not small companies that are doing invention. The FTC has power to influence this debate and even to fix the troll problem, again, through restoring the patent system for inventors and then going after troll behavior. So that's why I'm here. I'm excited to be here.
Terrific. Well, thank you very much. And Talal, I wasn't sure if you wanted to do your slides or, yeah.
Yeah, let me go through.
That's why I was pausing a little bit.
So I'm just going to kind of skip to the chase. I've got roughly 6 minutes left. To make a foundational invention, I'll just talk very briefly about some of the things I've done. I was the sole inventor of something called MIMO technology that changed 100 years of radio science, and that's used in pretty much all your wireless devices today. I did that research at Stanford. We started a company. We showed that it worked. That company was acquired. I did a second company which developed the Wi-Fi technology that's in pretty much every computer and every smartphone today. These things take hundreds of millions of dollars to develop and anywhere from 7 to 10 years to reach profitability. In order for a venture capitalist to get a payback on that kind of investment, the valuations need to be upwards of $1 billion. So when a large dominant competitor copies your invention and puts you out of business, we can't hope to compete with the market power, the pricing power, the engineering resources that dominant competitors have. When they put you out of business, the patents are there as a recourse. They used to be there as a way to prevent the competitor from putting you out of business because you own the property. But nowadays, it's more about trying to get a fair price for the investment that you've spent. We've talked about the eBay decision, which took away right to injunction. So there's really, and the latest example of this is just, I believe today, Qualcomm, in their dispute with Apple, showed the ITC that Apple was infringing on Qualcomm patents that were legitimate. And the ITC said, we're not going to give you an injunction. So even in a large company whose livelihood depends on intellectual property, we're no longer providing injunction, which means there's not a property right, there's a right to try to charge rent. So damage awards have also been dramatically reduced by roughly a factor of 10 over, say, the last 8 to 12 years. So this is just one example. If you look at, say, Apple, Google, Microsoft, and Samsung in the tech industry, some of the world's most important and powerful dominant competitors, there's roughly 1,000 cases that were brought against them post-AIA, and these are litigations. Of those, there were roughly 10 judgments. Recall that if you've got a few $100 million into an investment, you need, let's call it something just shy of $1 billion to get a good return for your investors after a 7 or 10-year period. So out of those 1,000 cases, 10 resulted in jury verdicts that were awarded that were more than $100 million, and none of those have been paid. The latest failure was Wharf University in a 7-year lawsuit with Apple, and what happens is the Federal Circuit has overturned. So these dominant competitors have become very, very good at a combination of serial IPRs where they may file up to 10 IPRs against a single patent to challenge the patent again and again and again. When the jury award comes down, they appeal, and then they do a new wave of IPRs. This is an impossible gauntlet for an inventor, for a small company. And so as a result, we have begun to understand this in the venture world, and it's influencing the type of investments we're making. There's a lot more investment going toward the type of companies that do software innovation, consumer apps, consumer apparel, social networks, things that don't really require patent protections because they're innovations as opposed to invention. And we're going away from things like wireless, semiconductor, core networking, drug discovery. These are things that as a percentage of venture capital have declined very dramatically over, say, the last 12 years. So this chart shows a couple, actually this is just US semiconductors as an example. The reason we picked this, everything in the world today rides on semiconductors, whether it's our consumer apps, whether it's a computer program to use artificial intelligence to discover the next drug, or whether it's a fighter jet. Semiconductor technology is underneath everything. And we're no longer investing in semiconductor technology because there's dominant competitors who are assured to copy the invention, and we can't really invest. So what can we do? I agree that there were actors, some call trolls, what I just call bad actors, who had patents for extortion value. The way to address those types of actors is by identifying behavior, and when you find them preying on small companies and not really ever going to litigation, and you can identify the characteristics of their behavior, then we should use trade law to go after them and prosecute them. At the same time, we should really restore injunction. We should have the right to own our inventions, and we shouldn't look at a giant jury award, what we consider to be giant, say $500 million jury award, as a problem when there's a foundational invention involved in that decision. And that will help start to restore things. There's other things we need to do at the USPTO. We need to end serial IPR abuse, this endless stream of arbitrary arguments to attack the validity of a patent. Another example, Qualcomm, Apple teamed up with Intel, filed 42 IPRs against roughly half a dozen patents together. So we need to end that behavior, and we also need to end the behavior of arbitrary invalidity arguments where you take 2, 3, 4 pieces of prior art, mix and match them, and an arbitrary combination of arguments, again, with serial IPR, trying to destroy patents. So those are some of the things we can do to restore U.S. invention.
Okay, well, I know you've raised a number of issues that the other panelists are going to want to address, but before we do that, I think I'd like to turn to Talal for your opening statement.
Thank you. So I'm sort of the poster child for a lot of this type of stuff, so I'm a little bit of story time. I run a company in Silicon Valley called Intertrust, which has been around for about 28 years. The company was founded by a guy called Victor Shear, who's sort of the classic sort of genius visionary entrepreneur who in the 80s realized that computer systems were built in a way where security was assumed to come from the outside. And people used to lock machines in a room and just rely on physical security to protect both the data and the code that was running on the machine. And the founder of my company realized that when a computer became a PC, and a PC became a cell phone, and a cell phone became a light bulb, and it was all effectively a computer, and these things were talking to each other over open networks like the internet. You couldn't rely on locking the machine in the room. The other thing you realized was that people would use these things in very different contexts, and it wasn't really clear who the, quote, enemy was. The military model of computing had basically broken and transitioned. So we ended up inventing a new way of writing operating systems where the data and the software in the operating system would be run in a protected environment. So regardless of where the machine was and regardless of where the information went, it was always not only protected, but governed. So you could always trust the computations as they traveled through the world. Cool idea, founded the company in 1990, had some pretty interesting character traits. One was sort of an understanding that if you came up with something tremendously disruptive, at some point a large company would show up and break your toys. And what Victor did was look around for the best way to protect his inventions, which of course was to file a bunch of patents, and ended up from 1990 to 1995 filing one of the largest patent portfolios in the area and developing a patent portfolio that for our field was on par with what Graham Bell did for the telephone or what Edison did for lighting and whatever Edison did. And then started fundraising and building a good old-fashioned Silicon Valley company. I used to be a research scientist. I used to work at a lab in Princeton that was funded by the Japanese company NEC. It was a basic research lab. One day somebody left the cage door open. I decided to move to Silicon Valley and become an entrepreneur, and signed up with Victor in 1997 along with a bunch of other folks who were sort of leaving mainstream research and engineering, and actually we employ a lot of lawyers because of our commitment to intellectual property. And we ended up looking for ways to apply the inventions. It turned out the music industry, another intellectual property industry, was being gutted by the internet and MP3. We ended up developing what's now known as digital rights management, which is a derivative of our inventions, and doing deals with the music business and helping start what everybody today does for entertainment, which is digital rights managed music on the internet. We did deals with the record labels. We went public, and whether it was a self-fulfilling prophecy or not, a small company from Seattle called Microsoft showed up and said, hey, we'd like to do a deal. And back and forth, the terms of the deal were just unacceptable to us because they involved Microsoft getting a license to all of our IP, whether or not they actually used the products we were making. We said no, and thus started turned into a huge patent war. Microsoft, we believed and asserted in court eventually that Microsoft copied everything we did, didn't take a license. We started to go bankrupt. We were public on the NASDAQ. We went public in '99, 500 people, and just decided we were going to go back and use the patents for what they were made for. We sued them for patent infringement. We were called all sorts of names. We had to lay off 90% of the company. We lived in the forest, ate squirrels, and fought a guerrilla war against the largest monopoly on earth at the time. And it ended up going private. We became a JV of Sony and Philips, two companies that have a very strong commitment to intellectual property and standards, in 2003. And in 2004, right after a very good Markman ruling in our favor, we ended up settling with Microsoft after a long negotiation for the sum of $440 million, which is one of the largest settlements of its type in the world. I became CEO at that point, about a year when we went private. And at that point, I started to rebuild the company in the image of a Qualcomm or a Dolby. I mean, we always had a very strong commitment to intellectual property research. Today we're about 250 people. We employ a Turing Prize winner as our chief scientist. We have an actual research lab, and we're fantastic innovators. We make products, and we also do a lot of licensing. The last 15 years has been an intriguing ride. Now, in the process, we also set up a strategic venture fund in the company, and we've been dealing with all sorts of issues, not only related to security and management of entertainment and media, but the security and management of distributed data sets across the internet. So today we're very active not only in the entertainment space, but also in the energy space with a lot of data management activities in automotive and so on. Now, in the process of being strategic investors, and this goes to a point that Michal made about trolls, we invested in a whole bunch of companies, one of which was at least at the time, was a small thermostat company called Nest Labs, which is now owned by Google. And Nest, in fact, started in a borrowed conference room in my building, and we were part of the early stage funding rounds with Google and with Kleiner Perkins. And I remember the first time I saw a Nest thermostat, I told the founder, I think Honeywell's going to be upset about this. And it took about 5 or 6 weeks after the launch, and I got a phone call at 7 in the morning from Tony Fadell, who founded Nest Labs, going, they did it. I said, what did they do? And he said, they sued me for patent infringement. So I was like, don't talk to anyone, we'll be there. I'm going back to bed. And what Honeywell did was kind of interesting. They obviously are not a troll under any definition of troll. But what they did was they sued Nest with a bunch of patents with the sole intention of bankrupting them. And Nest fought back. They were well-funded. They didn't have issued patents of their own, but between us and Google, we kind of helped out. They prevailed. They were acquired by Google a few years later for $3.2 billion, which was not only a good exit for us, but a great outcome for everybody. And Google acquired a great team and a great product. But in the process, what we learned was, in addition to patent trolls and everything that's going on, and we'll bicker over some of the details in the last two presentations. I have some opinions that agree and disagree with some of the comments that were made. There is a form of, it's not NPE activity, but it's a different form of trolling where large companies will attack innovators with intellectual property in a frivolous way with the intention of bankrupting the company. If you don't have patents to countersue with, you don't have the funds to fight a company like Honeywell, and other big companies do this all the time. I think everybody here remembers the IBM Amazon shopping cart lawsuit in the mid-90s. You go out of business, you run out of money, or your investors flee. And I know I'm running out of time, so I'll end with this. What we ended up doing years later was partnering with Google to create a program called Patent Shield, which we run today, where we run it like a venture activity, but we go to innovative startups and we provide them with a portfolio. I think it's about 1,000 patents right now that they can draw from in the event that they're sued by a product company, so they can countersue. And it's our own contribution for carving out a little bit of defensive perimeter around innovative small companies so they can actually go out there and innovate without the fear of being attacked by larger companies that they're disrupting. Now, if one of our startups or a startup was actually infringing somebody's patents legitimately, we're actually pilfering somebody's intellectual property, by all means they deserve to go down in court. But our intention is to find innovative companies and provide a defensive mechanism for them that really protects them from what happened with Nest and Honeywell. And we see this all over the place. We started the program about a year and some change ago. We've got about 3 or 4 startups in it today. We've got 3 or 4 more coming in. And it's a really neat way to interface with innovative startups and actually help them develop their own patent positions in addition to providing this defensive capability that not only help them defend themselves, but also keep their own patents clean so that they can continue to build on their patents. So with that, I'll hand over the last 10 milliseconds of my time to Suzanne, and we can discuss.
Well, thank you very much. We've touched on a number of issues that I want to explore on the panel. I think before we talk about some of the policy points, for me and I think for the audience, it's helpful to know that each of you are sort of involved, I think, in different stages and with different sectors. And so when you think about all of the issues that were raised in the opening, how do you evaluate the IP position of a company that you are either advising or considering investing in? And I know that at the beginning of this panel, we talked a lot about patents, but earlier in the day, we talked about trade secrets. Later in the day, we're going to be talking about copyrights. So from just sort of a personal business experience, what do you do when you sit down with a company and you're either advising them or you are looking at investing in the company? And I think we can just go down the line this way if that works.
Sure. So for the early stage companies or entrepreneurs that have an opportunity to interface with, the first question I actually start with is more on the novelty perspective. So I start with, what problem are you solving? Presumably, all of the speakers talked about enforceability of patents. So presumably the patent is being filed to protect some commercial product. So I start with the conversation on what problem are you solving, how does your technology solution solve this problem, and what are the current modes for, how are people currently dealing with this issue? So that's your competitive market right there. So I try to get an understanding of where they sit in the competitive landscape to really answer the question whether a patent filing is worthwhile. So in order to sort of get to that answer, we start with these sort of derivative questions. And then in exploring whether a patent filing is worthwhile, you look at other areas of intellectual property. So trade secret is not a useful tool in the academic setting because it's counterintuitive. Academics need to publish. Trade secret, it needs to be secret, so they are in constant conflict. But in the commercial marketplace, it's a very viable solution to have a trade secret strategy in conjunction with the patent filing strategy. So if that's an opportunity for the particular entity, I definitely explore that with them as well. Trade secret protection requires a lot more rigor and discipline, so it's not usually useful for a startup because an early stage company, you would need help. There are very few early stage opportunities that are completely contained, self-contained, and can grow with the 2 or 3 founders that started it. You don't see Microsoft very often anymore. You don't see Facebook very often anymore. So there needs to be some circle of trust within that. So patent filing is the other side of the protection that they can then go out and talk to potential suppliers and folks in the supply chain. And then the third piece, which you're going to get to this afternoon, is copyright protection. So that's definitely an option. It's unique, and there's some interesting stuff happening in the world of copyright. So I'm curious to see what our folks this afternoon have to say about that. But most people look to patents as a real sort of the 800-pound gorilla of IP. For protection and enforcement. So we start there, and then we look at other strategies based on the technology.
And I just have a follow-up. When you're looking at mapping trade secret protection and patent protection, for example, how does that go to either your valuation of the company or your expectations for business projections for the company, first? And then second is, how do you decide which rights to protect? If it's a company that is eligible for trade secret protection, how do you decide which rights to protect through trade secret and which do you protect through patents?
Sure. So from the valuation perspective, it really depends on the commercial product. So my time at Coke taught me how trade secrets can truly be an asset and truly be valued and have a valuation that's quite incredible. But you don't see that until time. So time is your determination of how really valuable your trade secret is. WD-40 is another good one. There's lots of interesting trade secrets that have maintained their secret status. It's really hard to determine that up front on early stage tech. So the trade secret benefit that truly comes out is know-how, know-how knowledge, what I call negative know-how, so you know how things fail. We all had some time in the lab, so we understand sort of your laboratory experiments disclose for you certain things that you may not want to put in a patent filing. So that level of process, step, know-how knowledge is perfect for a trade secret strategy. And then on the patent side, you're able to see that directly correlate to your commercial product. So your patented, your commercially viable features should be represented in your patent claim. So some of my critique of Greg's remarks, and Greg, you're a great person, but I do have some critiques on your remarks. When you look at some of the patent damages and some of the case law jurisprudence that we've seen over time, the reason the damages are going down, we sort of finally got it, that you don't get to claim, $1 billion worth of lost sales when the patented feature was really a $3 chip. So prior to some of the recent changes in law, you would just say the total sale of the product is really what drove the demand, and that's how I get my damages. Well, actually, the patented feature that your rights are directly related to in the damages case is related to the $3 part. So you only get the equivalent amount of damages related to that unit. So the law has changed to account for what's really truly valuable. And I'm not an economist. We had some really talented folks earlier today. But to me, that works with what you want from an economic market interaction with IP. So I like the outcome, and I understand how we got there. And now that we're there, we're smarter about what we think about when we start the filing up front. And we want to protect the features in the patent claim that really directly relate to commercial viability and the market, what they want. So, so that's part of the back to the trade secret patent strategy perspective. You're able to see that value in your patent if you can sort of protect those features up front.
Thank you. And McCall, it's sort of the same question. How are you evaluating the IP position? Because I do want to begin to tease out some of the different views I know that the panelists share with respect to the role of intellectual property and sort of anchor that in what you're looking at when you're evaluating companies.
Yeah, absolutely. I think similarly to Nicole, the novelty of a company is really the touchstone when we at Expo are evaluating a company, or I think any venture capital fund is evaluating a company. How, as Nicole was saying, are you addressing a problem? What is the problem you are addressing, and how are you differentiating yourself from the competitive landscape? What I would say is that filing a patent is rarely part of that initial evaluation for us. It's simply the case that in the environment in which we're working and in the industries in which we're working, the pace at which companies are innovating on a particular problem and are competing against one another just far exceeds the pace of filing for a patent and going through that system. And so, you know, when advising a company that is very early stage that is coming to us, we start to think about trademark protection and about patent protection as tools along the way, but rarely, in my experience, and admittedly, hardware is not an area that we focus on. And I can absolutely see that venture capitalists who are focusing on those areas might have different perspectives here. In the software field, in the internet technology field, the patent portfolio and trademark portfolio is a way for, as a company to develop, for it to build value, to attract further capital, to begin to differentiate itself once it has established itself, once it's gotten early stage funding. But again, the primary thing that we are looking at is a company's ability to outpace competitors and to stay ahead of the curve, and patent filing is not a major part of that evaluation for us.
Thank you. And I think Greg sort of asked.
Yeah, so this is actually a very complex question, and there's not a single answer. So we invest in a lot of companies like Mikhail invests in, and in that case, patents are not all that important. So if you're doing a consumer app, some twist on a social network, a new enterprise piece of software, you might be relying on open source where patents are largely unavailable. That doesn't mean you don't have value. And there you're relying on just time to market, excellence in the product, and a lot less money invested to get the product out. Generally, you do not invest hundreds of millions of dollars in a company like that until the product is proven, you show product market fit, and then you're investing your money not in an invention, but in marketing the product, a sales force, a worldwide marketing program, et cetera. We still want to see a patent portfolio typically for good practice, and just in case the patent system someday recovers, as we're hoping it will in the next few years, so that there is some value, and if nothing else, for cross-licensing value. But now shift gears. If you're talking about a new drug, a new medical device, a new way to do wireless, you know, we've seen some really interesting things for 5G lately, and it's become much more difficult to justify those investments, and that's across the board in the venture community. So what you're hearing is different perspectives on the same set of problems. We do see everything, so we change our policies based on what we see. Nowadays, trade secrets, so if you reverse the clock 15 years ago, trade secrets and patents were a choice. Now you really have to rely on trying to go fast and keeping everything secret. In my career, I've done 3 big inventions that have, really changed the market in wireless. All 3 of those were copied very quickly by dominant competitors. So it's 100% guarantee they will get copied. So you can try to keep them underground as long as possible with a trade secret, but that's not the same as a patent because you're eventually going to get copied. And they have literally 1,000 times the resources to put on the development that you do. They have market power. They own the customers. They control the debate, as they have in the patent world. So it's very, very difficult without patent nowadays to justify certain investments. I'd like to just comment on a couple other things. We see demand letters quite a bit, but we don't, generally, I've never seen a demand letter in the early stage. And after we had the pre-call, Mikhail mentioned she's seeing demand letters, when companies first get off the ground. And I said, I've never seen that. So I asked several of my colleagues in the venture world, and I said, have you ever seen a demand letter at that point? And none of us have, at least the people I talked to in a quick canvas. Where we see them is when a big success begins to become evident. So that's where maybe you're going to go public. You're a unicorn. You're worth $1 billion. Maybe you just raised $50 million in a fundraise. That's generally where we see these things, and you're a little more sturdy at that point. And I'll tell you who doesn't need protection against demand letters is the giant companies pushing the narrative in the patent world. Okay, when it's small versus big, that's a very different scenario than whether it's a bad actor or a large company attacking a small company. What we've done in general is made it so expensive and so time-consuming to try to defend a patent. You're talking 7 years, appeals, dozens of IPRs. There is no end to the process, and maybe it's a $30 million process over that time. That is an impossible gauntlet for a small company. So you might say, okay, I'm going to do a trade secret and try to escape, Earth's orbit and get into make it with the company without those protections. Sometimes you can invest in that, but that's a much riskier scenario than if you can own the product of your investment. One other thing, there's this idea that you should get a royalty on a chip that costs $1 versus, say, a phone that costs $1,000. This is called the minimum saleable unit. What it does is it motivates the manufacturer of the phone to try to crowd your intellectual property down into something they can say costs $1. And the best way to evaluate the value of an invention is to say, what would happen to that product without the invention? What would the market value be without that invention, regardless of where it goes in the product?
So we keep getting into a lot more interesting questions and much more interesting questions than the one that I've written down. But I want to give Talal a chance to answer this question, sort of how do you evaluate the IP position? And then Nicole, I know that you have a question.
People have hit a lot of the points. I'll focus on entrepreneur psychology and how we evaluate. I've got a bunch of trick questions I ask in a pitch just to make it go quickly, one of which is, why are you different? The other is, if you're successful, how do you prevent somebody from knocking off your product? And there's a basket of tactics that companies employ. One is just to run faster than the other people, build up enough of a base that someone's going to want to buy you for your market accomplishments. And there isn't a one-size-fits-all strategy. I've never really met a successful company that is going to purely rely on trade secrets. Trade secrets, I'm advising, it's actually an Israeli company spinning out of Tel Aviv University in the agriculture tech space. Very patent-rich area. They're coming out with a really good patent portfolio. They genetically engineer plants that complain louder when they're sick than when they're not sick. And then they've got nanosensors that detect that the plant is sick. It's a very cool idea. They're going to depend on their patents to go up against the Monsantos of the world. At the same time, the techniques for genetically engineering a plant are going to be trade secrets. Now, the woman who's running the company is brilliant, but she doesn't have a lick of intellectual property expertise. And in that situation, we've been advising her on how to create an entire intellectual property strategy. And there's always a way to fit an intellectual property strategy to any technology venture. Now, it may be you're in social networking, you're in the data space, and you're using a bunch of open source tools. So by definition, most of what you're going to do is going to be open source anyway. That is an intellectual property strategy. You're using the sort of the ICE9 of the open source system to basically defend yourself by not having any defenses. A lot of people don't know how to play that instrument very well, and they need to develop an IP strategy themselves. The last point I'd make is we've talked a lot about, light bulb patent, go to market, but on the internet, a lot of the stuff that's being done is in the AI and the data space. And I don't know if you went to that panel, the conference we attended in Sweden, but there was an attorney from Microsoft who brought up a really interesting set of issues about there not being any really good intellectual property mechanisms to actually protect data. Data falls between the cracks of copyright, patents, trade secret, and there's all sorts of cases where, like, can you copyright a phone book? Can you use the data in a phone book even though it's copyrighted, stuff like that. If you look at the largest companies in the world today, Google, Facebook, Netflix, Amazon, they're all data-driven. And, Google goes to extreme lengths to protect the trade secrets that allow them to analyze the data for their profit. Facebook does a lot of that themselves. But if you have a large data set you've accumulated through a bunch of algorithms you've developed, you probably can't patent the algorithms because you used a bunch of open source tools to develop them. Right. And then you fall into all the oddities around software patents. Your data is your intellectual property, right, but there's no clean way of going after people who grab it or make inferences on it. And that becomes a really tricky differentiator as well. And all of the problems we're talking about with the patent systems have to do with the fact that, by definition, and we want it to work this way, the law lags innovation. And there's always this undercompensation, overcompensation effect. The whole PTAB IPR thing is literally a hack on a system because people couldn't wait long enough for the law to adapt. So we've done a bizarro retrofit that's done a really good job at tamping down NPEs, but it's taken a lot of, there's a lot of crossfire and a lot of collateral damage in the process. But the system will eventually catch up and clean its act up. And I agree with Greg. I think the FTC can do a lot to sort of come in on the perimeter of what the PTO is doing and sort of help the system act more rationally until the rest of patent law sort of comes into play. I'll give the floor back to you, Suzanne, but one thing I think we might want to address is actually the context of American innovation operating in a much more globalized world where people who'd never used to file patents and deal with IP systems like China are actually becoming more assertive and more aggressive than we are, yeah, and innovating in their own odd way. And there's actually a global trade aspect to what we're discussing. I hope we can come back to it in the context of some of the questions that come down the pike.
I think that's an interesting point. Nicole, I know that you had a question.
Yeah, no, the panel is kind of taking a life of its own, so if it feels like we're sort of scrambling, it's only because there's lots of interesting issues that are coming out of our comments. I wanted to go back to something Greg said. I think it's a little bit more complex, and I actually want to learn a little bit more about how you guys deal with these investment decisions. So you've mentioned that the pharma, medical device, that they're just not as attractive as business investments. But my question points to, it's really what stage are you looking at pharma and medical device? And is it really because it's a patent problem, or is it the regulatory issues and the uncertainty in terms of toxicology data and the uncertainty in terms of efficacy for those particular industry sectors that make that a less attractive or more difficult investment? So can you
Yeah, that's actually a great question. So there's no doubt that in addition to intellectual property, et cetera, in life sciences, regulatory is massive, and regulatory goes through phases where it can be easier or harder to get approval for something, and that greatly influences the outcome of the investment because it stretches out the time and increases the risk. When it's harder, it makes it better when it's... What I was saying is that, here's an example. So let's say you develop a fantastic medical device, and let me just say this. So these new techniques, and there's actually a paper by U.S. Inventors for Jobs that you should all read that's coming out shortly that I just saw on serial IPR abuse in the patent system. And this is where a giant dominant competitor can file as many IPRs as they want until the patent is dead. And it's extremely effective. And so what's happened is the dominant competitors practiced on small companies first perfected their art of destroying patents over periods of time, and now they're going after some of the most important intellectual property producers in our economy. Genentech and life sciences is now, it's no longer about the troll patent. These techniques are so good at killing patents that the most valuable patents in life science are now being attacked. The most valuable, Qualcomm, the most valuable patents in the world for wireless are being attacked. And so when you face that kind of environment and you're building, say, a medical device, you have to say, can we keep it under wraps long enough to get out there? And when is that disease that's happened starting in the tech world with the dominant competitors going to come to my industry? And now we see it migrating from tech into some segments of the medical industry. So the disease has to be stopped and reversed so that great patents, wonderful inventions can be rewarded. So no question in life sciences, the other regulatory factors are at least as big, but still, if you can't protect, for example, when you could have an injunction for 15 years, you knew for 15 years that medical device was yours to produce. Nowadays, it's, okay, how long can I stay ahead? And once it becomes a big market, someone's going to put 100 times the resources you were able to put. So maybe it's 7 years or 6 years, and then that factors into the investment thesis. And so then that degrades the valuation, which degrades the amount of money you can invest, which may prevent that from coming to market.
A couple of rebuttals. One, serial IPRs are really hard to do. So let's drill down a little bit on IPRs, right? So you from a startup perspective, there are very few startups that have more than 5 patents. It's hard. It's almost impossible. So serial IPRs are difficult to do because there's an estoppel provision within the USPTO that says if you bring all of your claims, or you need to at least in your initial filing, bring all the claims that you reasonably could have filed at this time. So there are some protections within the system to stop that. But I'm not saying that people haven't figured out a way to game it. But it's not gameable as easy as some of your remarks tip the scale towards a little bit, in my opinion. And then the other part, as far as oh gosh, there's so many things that you said that's rich. Oh, I lost my train of thought on the second part. But the serial IPRs, I wanted to at least.
I hate to, hopefully this isn't too wonky, but this is super critical. This is just one example of the abuse that's occurring. So I kind of feel like you just lobbed me a softball, so thank you.
No, it's okay.
So this paper that'll be coming out, and I think it's coming out within a week, it actually is similar to a paper that came out in IP law a couple weeks ago, shows how the dominant competitors, especially in tech, are completely subverting the intention of the AIA and filing up to 12 IPRs against a single patent. And they'll also practice something, if it's a small company they're going up against, they'll practice something called portfolio abuse, where they say— Are these
being instituted, or are they just being filed?
Many are. Yeah, eventually. Here's the thing with IPR. If you can keep filing, there's a gambling effect. So you're dealing with human judgment on these panels. Some patent judges in the panels are more favorable than others. And eventually you get a panel where 2 of the 3 are favorable to one of your arguments, one of the, 2, 4, 6, 12 arguments you've been able to make and you've been allowed to make. And they're very similar arguments involving combinations of art that are often arbitrary. This is happening, and there's data on it. It's being published. This is a fact, and it's something that has to be fixed. And it's one of the most deadly things happening to inventors right now that's out there. That in combination with arbitrary assemblances of prior art references. Take 2, 3, 4 prior art references, mix and match them in 5 different arguments until somebody says, hey, I think that's right. And then you lose the patent.
You're protesting too much. I mean, I agree with you, the system's overcompensating, but Apple versus Qualcomm is a bad example. That's called a negotiation where I come from. You've got 2 IP giants, and Apple's not exactly an angel. They sued the crap out of the entire mobile space, and they know how to stand behind their patents, trying to figure out a cheap deal on chipsets, and they're going to the court for that. In terms of IPRs being used, big companies hitting little companies and things like that, this is a technique that's available, and far be it my role to defend the way big companies defend themselves, but it's a technique that's available to them, and if they're sued, they're going to fight back with whatever's at their disposal. 15 or 20 years ago, There were no IPRs available, and what would happen is you'd sue Mr. Big in, in San Francisco, and Mr. Big would countersue you in Australia.
Right.
Because it was like really expensive for Joe's startup to go to Sydney to defend himself. So the minute you're in court, it's a war. Both sides are going to use every tool at their disposal. We now have a tool that's being overused. And as I said, the system will compensate back, but you're picking on these anomalies to amplify the problem. And to me, it doesn't seem that bad.
Yeah, so if I can just completely disagree. So again, please read the paper. There are tons of examples of small companies. Wharf is an example, which is a university.
Wharf is not a small company, by the way.
I mean, you get people like the regents of the University of
I'm going to jump in here because I think that
Wharf is not a small company. University of
No, I
Wisconsin.
said it's a university, yeah.
Yeah. But they have several patent victories. So the reason they can fight for 7 years is they're quite successful.
Well, the endowments of these universities are bigger than the
They're
market
quite
cap of a lot
successful.
of companies.
Yeah, so
We're
here's a question.
We're getting
the
adversarial.
the adversarial part is fine. I have no problem with that. But it's more about, honestly, listening to this transcript and thinking about how I'm going to use it in a report. So I am very
let's go
grateful
back and help
to have
you.
you guys talk about these issues. But I think one thing that's interesting to me is, the FTC has weighed in on a lot of these issues. We haven't really weighed in on the PTAB issues very much. And tomorrow, if I can make a pitch for tomorrow, as I did this morning, we're going to have Patent Commissioner Hirschfeld and the acting chief judge of PTAB, Judge Borlick. So we'll be talking about some of those issues. But I think that, as I said, I don't mind the adversarial nature, but if we can kind of talk about specific instances that have happened to you and specific recommendations that you have for that issue, because we can talk about Apple and Qualcomm, that's okay, but we don't have Apple and Qualcomm here, so that's not, in terms of using that for my purposes in a transcript, that makes it a lot more challenging. So I think, and Elizabeth and I have been talking about how to sort of ask these questions, and I really don't want to exclude Elizabeth because you have a lot of interesting thoughts on this. So I think maybe now is a time to turn to some of the points in Greg's slides, and as you're answering these questions, thinking about how it's impacted you in your particular industry and to the extent that you can make the most specific recommendations possible. So for example, I think what we were just talking about with serial IPRs, that's something that would give you a chance to say, okay, are there, from a research perspective, are there serial IPRs happening? Are they serial IPRs, or is it different prior art being brought against different claims in the same patent? Because to me, that's a little bit different. So that's just an example of what I'm talking about, but I want to give Elizabeth a chance.
Thanks, Suzanne. I just want to return to a point that Greg made earlier in his slides, that IP remedies today no longer justify the risk of investment. And I'd like to hear thoughts from the other panelists as to whether you agree with that statement and whether investment decisions have adapted or changed to modify that trend, and also what factors the FTC should be looking at in this discussion.
We advise all the companies we invest in to build strong patent positions. And one of the things that really attracted me to Nest in the beginning was he had a serious commitment to building an intellectual property portfolio of his own and actually has some really good patents. And that not only goes to their ability to defend themselves, but in an exit scenario, it's another brush of color that adds value to an exit. If you have a strong patent position and everything else has failed, sometimes people buy you for the patents. If you have a strong patent position and you're succeeding, that will make an acquirer feel better about buying in. I think that every good American entrepreneur should be building a strong intellectual property strategy, and we encourage all the companies we invest in to do so and help them.
Yeah, and I would agree with that. And, setting back the statistic that I mentioned earlier, there's the 44% increase in R&D spending from 2012. I don't think anyone can look at the current investment atmosphere and say that that it is declining or that venture capitalists or other investors are hesitant to invest in the U.S. market. I think quite the opposite. Very similarly to what Talal said, intellectual property is an enormous asset for a company. It is a strategy that entrepreneurs need to be thinking about from the earliest stages, and whether that comes from the development of trade secrets, whether that comes from filing patents for legitimate inventions that they are accomplishing along the way as they build their company, whether that's building a strong trademark portfolio and building a brand around that. That is something that we very actively advise our companies to do. There's one point I wanted to go back to that I think Greg has been citing as one of the obstacles that has arisen for inventors, and this is the issue of injunctions. I think Greg is citing an eBay case from a while back, and just to clarify, injunctions are still available to patent holders the way that injunctions are available to any other litigant in this nation. It is simply that eBay decision simply that, which by the way was a unanimous decision in the Supreme Court, simply brought the field up to a place of equality where patents no longer got this exceptional rule of an automatic permanent injunction. And they simply had to prove that they were entitled to a permanent injunction the same way any other litigant does by meeting the four-factor test. And when they meet that test, they receive an injunction as anyone else would. It simply does not simply sort of took the favor that was the exceptional favor that was given to patents and treating it as though it was kind of personal property and equalizing that a little bit. So one additional point that I would make, and I would like to harken back to something Talal said, and I'm very, very glad that you brought up the point of dominant industry players using, that it's not just trolls who are engaging in troll behavior, not just non-practicing entities, but it is a very, very common practice that I have seen at both companies that I've been at, where projects on Kickstarter as well as companies in Expa's portfolio have been targeted by dominant players in the industry, bringing spurious claims, usually filing against dozens of defendants at the same time with non-particularized pleadings and complaints, often alleging use of technology that is not even used by certain of those companies. So to the extent that the FTC can help to further the project of getting particularized pleading standards, making sure that venue, I think, has been addressed by the Supreme Court to a large degree, but to the extent that the FTC and the USPTO can continue to ensure that venue is not being abused, I think these are the areas where we can see improvements in the current system.
And I think that's a theme, correct me if I'm wrong, that each of you have raised. And so I think that that's an interesting point, because as you were talking about that, I was wondering, were these sort of issues that you were seeing before the abolition of Form 18, or are you still seeing them? And the reason that I'm asking this is tying back to sort of the tools in the FTC's toolbox. When we issued our PAE report, one thing we saw was the potential for nuisance litigation among some players. And so our recommendations went to litigation behavior. And it's fair to say that that was criticized, and I think that's right, and we take that into account. But I'm wondering, as you are talking about what you're experiencing as investors in early stage players or elsewhere, and the idea that you have companies that are bringing sort of serial litigation, how do you address that? And is that taken care of with Form 18?
What is a serial litigation? Let's make sure we understand.
Well, I think what I'm, and I don't want to make sure I'm not paraphrasing you in the wrong way, but if you're saying that as a small company or as a entry company, you have some, and as I'm sort of saying this, I want to make sure that I'm not saying it in the wrong way. So maybe I'll ask you that. Do you think that that's a fair characterization of what you have said? And if it is, what remedies would be necessary? Because as I'm thinking about this and as I'm listening to all of you, I'm thinking very clearly of the FTC's role in trying to make sure that we're hearing everybody and balancing all of the issues.
So there, in general, innovation and investment in small companies in the U.S. is booming. I agree with Mikal. What's happening is where we're investing is changing. And I want to take us back to that because it is a fact that certain industry segments are underperforming in percentage of U.S. venture capital compared to others as a result of the fact that our intellectual property laws have changed. And the data is there. So I think I encourage the FTC to look very deeply into that and ask the question, is that the incentive we want to provide? Second, there are abuses on both sides. I fully acknowledge this notion of a bad actor that attacks small companies. But there's also another kind of abuse which we haven't even talked about. We've talked about big companies suing small companies over patents, but we haven't talked about big companies having policies that they institute that say, don't pay any attention to patents, don't look at infringements, ignore until you get sued, and then go scorched earth policy and IPR and litigation. And so, you asked us to provide real-world examples of personal experience and also not to talk about companies. So I have personal experience twice in the last 8 years with companies being approached for acquisition that have fantastic technology. They get their brains picked for 2 or 3 weeks. And then the large dominant company says, instead of $1 billion, we've decided this is only worth $50 million. So if you'd like to sell for that, fine. Otherwise, we're going to do this ourselves. And then the small company says to the executive, well, we have patents. And the large company says, let me tell you what we do to people who approach us with patents that are like you. We sue you with our own patents. We take you to court. We file an IPR against your entire portfolio. That's called IPR abuse in a portfolio sense. Not just the ones you're going to come at us with, but your entire portfolio. We'll put you underwater there. And then, if you win in court, we'll appeal and we'll keep you going for 7 years. It's going to be a massive expense for you and we'll put you out of business. I have seen those conversations take place. They happen all the time.
But my company is living proof that if you don't take that and you fight back, you win.
If you can raise the capital, so then you have to go out to, I agree.
Well, so, I mean, that's the point of business, right?
In today's world, I'm not sure that's true anymore. 10 years ago, yes, because I think that's in the order of the time frame you had. But in today's world, you go back to your venture capitalist and say, I'd like $30 million to fight giant company A. And that's generally not a very popular investment today.
Well, I will also say that IPR didn't introduce any new avenue for claims that didn't exist before. These are claims that would have ordinarily been brought through litigation, which is significantly more expensive for both parties. I don't think that the large parties that you're talking about that are using this in a weaponized way would be cowed by the cost of litigation.
True,
comparatively to IPR. So IPR simply makes it more affordable and frankly easier for the person defending the claim.
That's the argument, and I'm sorry to be the thumb that sticks out today, but there's a reality out there. So in court, you got one bite of the apple, and you get to make one argument, and then the court decides whether or not your argument is right. The rules in IPR have been different. Hopefully they'll be cleaned up, and they're looking at it now. But you can make many, many arguments. You can also, there's evidence of collaboration in the market where giant competitors collaborate through firms like Unified Patents and also directly. Like take, for example, I won't name any names, but they collaborate with each other. And you may see, like I say, a dozen IPRs. That's a dozen bites of the apple, whereas in court you got one.
So, Greg, if I could ask a follow-up, when you're talking about this, because I think you talked about a valuation issue and an IPR issue. And what is what's your recommendation for addressing that? Because I think, the IPR sounds like it's just one component.
Yeah, IPR, arbitrary combinations of art, BRI, which are addressing, clear guidelines on Alice to make Alice more predictable. And then the realization that a large jury award for a very substantial invention is fair, and then hopefully return of some kind of injunction. Just to address the earlier point on injunction, ITC cases, a minority of ITC cases are found to infringe. Once it's found to infringe, there's an 85% failure rate from the time it's found to infringe to injunction. So you're looking at a
do you mean exclusion order?
Yeah, an ITC. So, and a lot of those injunctions are temporary. You're looking, so as an investor or as an entrepreneur, you say, okay, I have like a 95% chance of failure of getting injunction after I make all the arguments, after my invention's been copied. You have to assume that's unavailable in today's world.
Okay, I think we'll, it's a good idea to go back to the data in terms of the ITC issues, because I don't have that at top of mind. But I think, one issue is always separating out the 337 standards and the standards for an exclusion order. And I think, in the past, to be fair, the FTC has supported eBay because as a matter of our policy, we have said that there shouldn't be special rules for intellectual property. And so, one of the things that we're doing, and that extends in several places. We say that there shouldn't be special rules for intellectual property. We say that we don't presume that patents will give you market power. That was sort of more unique in '95 than it is today. We say that patent licensing generally is pro-competitive. So it's a leading question, but are you sort of suggesting that we should have different rules for intellectual property than we have for other marketplaces as we're looking at?
Well, so you have to ask yourself, is it property? Right now, it's not. So yeah, I think there's also a question which becomes extremely complicated, and I can't pretend to understand how to resolve it, but it's a question I think that should be asked. Is an injunction for a small inventive company who depends on that invention to create a return for the employees and the investors, is that the same as an injunction for a giant competitor that probably doesn't need the injunction to live and survive and profit? So, I think that.
Yeah, I'm just thinking about the 4 eBay factors and
Yeah,
how
I
that
have
works.
them here. Yeah, the patent owner must show, we're talking about injunction, so let's get to the test. Irreparable harm, that money damages are inadequate, the balance of hardships go in favor of the patent owner, and then the public interest would support a permanent injunction. So what eBay did is harmonize the law. So as McCall mentioned, before we had sort of a special case for IP, the Supreme Court said, no, we've always allowed parties to argue for injunctive relief, and this is the test. You in a patent case must follow the same test. Now, if you can argue and show, and there are cases in the pharma industry where it was Sanofi versus somebody else, I just looked at 2 of them yesterday, where they were able to prove and show that there was irreparable harm and money damages would be inadequate. And in the article I read about it, it's usually if it's a 2-player market, so going back to economies of scale, so you've got 2 either small players or dominant players, it doesn't matter, but they have the entire market. And one of them is infringing on the patent, and they argue for a permanent injunction that the court has granted that because there was an ability for the pharma company to show irreparable harm.
Yeah. So not to use specific company names, but it's very timely. So I think this morning an order came out from the ITC with the Qualcomm case.
So that's a different standard, just to be clear, that the exclusionary order standard is not the same standard for a permanent injunction.
Fair enough.
Yes.
We're talking about exclusionary,
we don't want to
which is
conflate those
on the
issues.
way to a permanent injunction. So this is a first step.
So yeah, no, and actually, I think this is a really fascinating conversation.
I actually have a point I'd like to make.
Yeah.
So they were not allowed exclusion because preventing some other chips from coming to market they felt would harm the public because prices would go up. But let me just say, I would ask the FTC to evaluate the following question. Yeah, that's a short-term price increase for a product, perhaps, or maybe not. Maybe the prices are equivalent. But what's the public harm to suppressing invention because you can't own an invention anymore? There's a different kind of harm that occurs when you decide there is no such thing as property in the word intellectual property. So I would ask you to look at that.
Well, Suzanne, I actually want to go back to just a word that you mentioned, which is competition, right? What does a permanent injunction do? It shuts down the use of a particular patent and largely will shut down that company. It eliminates competition. So while we are talking about the value of intellectual property and how that will encourage invention, we also have to be very wary, as I mentioned in my opening remarks, this balance between innovation and competition. And I think that the kinds of standards that Greg is putting forth are ones that shift the balance very heavily in favor of innovation and essentially create a marketplace where there can be no competition, where the simple assertion of a patent infringement suit can put another company out of business. And when I was at Kickstarter, we would always talk about how we want to compete on the basis of our product and to always just be sure that we are able to provide the best product that is up there, and we want to compete against competitors. We want that competition to exist. And I think, unfortunately, the patent system is very frequently used as a way to simply ensure that there is no competition.
Well, I'm sure we all would like to keep, I would honestly love to extend this panel by 2 hours, but I do not have that authority, and I know that there'd be very angry people if I did that. So with that apology, and with apologies to some of the questions that we've gotten, and that go to your question to all of globalization, so I'd love to find a way to keep this conversation going. I'd like to turn this over to you for your final statements, and if we go over by a minute or two, is that okay? Okay, thank you.
So we talked about a lot of different issues, and hopefully you guys are able to keep up. Some of the things in terms of closing remarks that I think would be helpful for what you need to do as you go forward. I think there is, despite our critique of many comments from Greg, there probably is some issue with serial IPR filing in some anomaly cases. So an argument could be made that that's stifling competition, and I think that the FTC could play a role and have some work with the PTO in terms of looking at some of the new, the IPR practice, and maybe some of the other new practices within the Patent Office, and whether or not that's having a negative impact on competition or a negative impact on the marketplace in terms of allowing people to continue to either have some business rights, or through their intellectual property rights, their competition sort of harms there. That would be my suggestion for how to look at addressing that.
Thank you.
Yeah, and agreeing with Nicole, and I actually completely agree. I think we are at the core probably trying to get at the same thing, which is a patent system that, like I said, balances these interests of innovation and competition in the best way possible. I by no means think that the AIA is the perfect solution, but what I would say is that it is the IPR process, the various Supreme Court decisions are good first steps to get us there, and I would encourage the FTC, together with the other government actors here, to continue to build on that, to investigate any issues that seem to have arisen with the IPR process, to talk with all of the actors here, whether they are small businesses and startups or inventors or pharmaceutical companies or research institutions, all of them, and fully understanding and understanding that each is going to present their side as though it is the be-all and end-all, but the truth probably lies somewhere in between. And I think through progressive improvements, we can hopefully end up at a system that really draws on the different parts of the government. And it's really wonderful to see the FTC engage in this and not just say, this is the job of the USPTO, but really see how we can identify each of the problems that exists in the patent and intellectual property system and kind of marshal resources together to address them. Thank you.
Yeah, so we're at the end of a 15-year cycle that started with a group of lawyers at a big tech company that invented the term patent troll because their CEO said, I want another 1% profit margin in my product, and those silly royalties we're paying are degrading that profit margin. And after 15 years and hundreds of millions of dollars spent influencing the debate, we arrive at where we are. And we're now in a regime where we have influenced where we're making investments. Big inventions that require patent protections are far harder to justify an investment in today. And that flywheel is in the process of spinning down. And we will recognize at some point what we've done. This is not the first time in our economy this has happened. Just two examples. The same exact debate, if you go back and look at history, happened around the turn of the century, 1900, around the electric motor. And the electric motor was, there's too many patents, there's something akin to a patent troll, there's no room left for innovation, et cetera. Happened again when the television set came. So we go through these cycles, and when we punish patents, we find out later that we're not investing in fundamental technology, and we go through cycles as we did in the 80s where we returned invention rights and saw a boom in fundamental invention. So it is the ability to own an invention that allows small entities to take on giants. That is gone right now for some types of invention. And I hope that we can restore that. And I want to just say one more thing. Other countries are recognizing our history, and they're actually providing far greater invention protections than we do now. Just two examples, Germany and China, of all places. It's now easier to protect an invention in some cases in China, and far easier in almost all cases in Germany than it is in the United States. And I would just ask the FTC to look at what's happening overseas, and that is the one way we do, you can protect your invention, but it's not in the United States, it's overseas.
So I'll start by saying that I agree with the envelope of what Greg was saying. I think a lot of the points that have happened over the last few years are actually somehow impeding innovation in the United States and indirectly harming consumers, in some cases directly harming consumers. Although, in terms of the specifics and how things are evolving, we have a system that's really been put together to patch up not only flaws in the way people are using patents against each other, but also the way patents are being issued. One of the issues is when you look at China as a case study, they have the ability to throw thousands of examiners onto the patent system to deal with the increase of filing. And ownership of intellectual property has become an arms race between countries and within countries. I mean, and there's a race to generate more patents, which obviously affects the quality of patents that are coming out of a patent system because the examiner can only do so much in a day. And there's dealing with that through the PTO process is really complex because you don't want to kill the baby with throw the baby out with the bathwater, and it's a very, very slow-moving process. Now, this is all playing out in a world where there are more patents being filed, more startups being started, more innovation taking place per day, not only in the United States but across the planet, and the chain reaction that takes place as a result of the embryonic development of an invention is now playing out on the street, whether it's patent warfare between companies or eventually the way companies are using patents to stifle innovation. And it really does land on the FTC's doorstep. And you folks get to look at the system from the outside in and filter the transformation that's taking place into the system into something that's more palatable for the market. The other thing I would point out is we're sort of at the end of an innovation cycle where you have this percolation of ideas that have resulted in a few really, really, really large companies. And obviously patents and the use of patents and the functioning of a monopoly or monopolies, they're very close cousins. And looking at the way people with substantial market share are using their weight in a market to impede innovators from moving to market and growing themselves. And the use of patents within that drama, I think, is something that needs to be examined very, very closely. And that ultimately is harming consumers if it plays out in the wrong way, because you're literally killing ideas before they get to market or copying certain elements of an idea that serve your business and help you maintain, I don't want to say monopoly, but effectively large market share position. And that's an area where I think there should be much more activity and inspection.
Excellent. Well, thank you all very much for your very thoughtful contributions to today. I am serious. I wish I could keep you up here for another 2 hours, and I'm sorry that I can't. But please join me in thanking our panelists. Thank you. Good job.